வணக்கம் அனைவருக்கும் மாலை வணக்கம். Good evening everyone. Today we all assembled through this virtual conference. The virtual conference, all the participants requested, please switch off your mic. There is a small button the side, the red light, that is you have to switch off the mic. When we want to call the speaker, we will call, then we will request to open the mic. Otherwise, please switch off everyone. Then only we can conduct this conference peacefully and a very good manner. So I am requesting everyone, the step number 1, to switch off the mic. And now we can start the proceedings. I am Dr. V.R.S. Sampath, editor Sattakadir, Tamil Law Journal, published in Chennai from 1992 to till date 28 years. The only Tamil Law Journal comes from Tamil Nadu, is Sattakadir. Please switch off the mic. Please switch off the mic. Cooperate everyone, please. This conference on 28th year, every year we used to organize a conference on law and justice. 3 years back, we celebrated Silver Jubilee also. I am welcoming Honorable Justice Indira Banerjee, Madam, Judge of India. She, Madam, participated in our function as a chief guest in 2 years back when we organized a grand gala conference in Hotel Lee Meridian Hotel. She participated and she awarded for various VIPs and important people on the day. Madam given a wonderful speech. Today she came as a participated as a chief guest of today's inaugural ceremony. I'm welcoming Madam about this inaugural ceremony. அதே போல சென்னை உயர் நீதிமன்றத்தினுடைய இன்றைய நீதிபதி, நாடறிந்த நீதிபதி, தமிழறிந்த நீதிபதி, எங்களுக்கெல்லாம் உறுதுணையாக இருக்கிற நீதிபதி, நீதியை நேர்மையாகவும் ஒழுக்கமாகவும் சொல்லுகிற நீதிபதி ஆனரபிள் ஜஸ்டிஸ் டி ராஜா அவர்கள் இந்த நிகழ்ச்சிக்கு தலைமை தாங்க இருக்கிறார்கள். அவரை உங்கள் அனைவரின் சார்பிலேயும் வருக வருக என்று நான் வரவேற்கின்றேன். அதே போல இந்த நிகழ்ச்சிக்கு உலக மாநாடு என்பதனால் we converted as a global conference. We like to invite the international judge, the very popular judge from Malaysia, Federal Court judge. He served as a highest court of Malaysia as a judge. He is a very extraordinary, brilliant judge. He used to visit very often to Chennai. He knows Tamil very well. The Tamil personality sitting as a judge and also top-class legal personality, Justice Gopal Sriram, former judge of Federal Court of Malaysia, is here. I'm welcoming Honorable Justice Mr. Gopal Sriram. Vanakkam, sir. Vanakkam, vanakkam. Okay. And now I'm welcoming Justice Vimala. Justice Vimala, part-time member, the full-time member of Law Commission of Tamil Nadu and also former judge of the Madras High Court. She got a doctorate also in law. She served in a different capacity. She presented a paper in different conference, participated in different conference. I'm welcoming Madam for this conference and present your paper. Another important personality from Seychelles. He is also former Chief Justice of Seychelles Supreme Court. He studied in Madras Law College in 77-80. He served in different capacity in Seychelles. Now he is retired. I am welcoming Mr. Justice Mr. Karnagaran, one of the popular person from Seychelles, will present his paper. Welcome, sir. And another important guest, Mr. A. Sankaran, former sitting full-time member of Tamil Nadu Official Language Commission. and also is practiced in Dindivanam as a lawyer. He's an extraordinary person. He is with us to present a paper. I'm welcoming Mr. Shankaran for this wonderful conference. And I'm welcoming Mr. R. Vidudalai, Senior Advocate from Madras High Court and former Advocate General and member of the Tamil Nadu Bar Council to present the paper today's conference. I'm welcoming Mr. Vidudalai. Welcome. Then again, another important VIP. I'm inviting, sir, I'm inviting Mr. M. Gandhi, Dr. M. Gandhi, the Dean of VIT School of Law, former Joint Secretary for Ministry of External Affairs, and former professor of Pondicherry Law College. This year, I'm welcoming Mr. R. Gandhi to M. Gandhi to present this paper. And I'm welcoming Ms. B. Nalini, former president of Madras Women Lawyers Association. She will present a paper on women lawyer issues. I'm welcoming all participants, all advocates, VIPs to participate in this wonderful inaugural ceremony and conference. Sattakadir serving very well in Chennai and in Tamil Nadu, publishing High Court judgment, Supreme Court judgment, various act law, translating from English to Tamil and circulating all over the Tamil Nadu. This journal is very much useful to the district court and subordinate court and even High Court, lawyers and judges and common public and litigants buying this journal. And also we are regularly conducting seminar, workshop, conferences, and also we are giving awards and rewards from time to time. This journal started in 1992, launched on the day by late Justice A.R. Lakshmanan. Then after that, the website was launched by Honorable Chief Justice of Supreme Court of India, late Honorable Justice Balakrishnan, the former judge of the Supreme Court of India. Then e-paper was launched by former Chief Justice Sadasivam. 25th year annual ceremony celebrated and participated as Chief Justice by Honorable Madam Indira Banerjee. It's having a long history, and we got a support from various agencies, government and non-governmental organizations. We are very happy to organize this conference in the Corona pandemic time. We are unable to meet each other. We are facing problems. The world is facing, everyone is problem. This is an opportunity meet only through this virtual conference. I am welcoming one and all. உங்களை எல்லாம் இந்த நல்ல நேரத்திலே சட்டக்கதிரின் மூலமாக வரவேற்பதில், உங்களுடன் கலந்து கொள்வதில், உங்களை எல்லாம் ஒன்று சேர்ப்பதில் இந்த சட்டக்கதிர் விழாவின் மூலமாக நான் மிகுந்த மகிழ்ச்சி அடைகிறேன். சட்டம் தமிழ்நாட்டு இந்தியாவில் எடுத்துக்கொண்டால் சட்ட மொழி ஆங்கிலமாக இருக்கிறது. அந்தந்த மாநில மக்களுடைய மொழி வேறாக இருக்கிறது. மாநில மக்களுக்கு தக்கவாறு மொழிகள் மாற்றப்பட வேண்டும் என்கிற வாதமும் நடைபெற்றுக் கொண்டிருக்கிறது. ஆகவே நாங்கள் எல்லாம் ஆங்கிலத்துடன் எங்களுடைய மாநில மொழியும் வேண்டும் என்ற கோரிக்கையை வைத்துக் கொண்டிருக்கிறோம். நீண்ட நாட்களாக அந்த கோரிக்கை நிறைவேறாமல் இருக்கிறது. இந்த நேரத்தில் அந்த கோரிக்கையை வலியுறுத்தி இங்கே வந்திருக்கிற அனைவரையும் மீண்டும் வருக 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 என்று மனமு வந்து வரவேற்கின்றேன். I am very happy to welcome one and all. Thank you. I am requesting all the participants to maintain their time limit. As Madam, before starting inaugurating the this conference, I am requesting Justice T. Raja will deliver his presidential address. After that, our chief guest, Madam Honorable Madam Indira Banerjee will give an inaugural speech. I am requesting Justice Raja to deliver his presidential address. Switch, you can unmute your switch.
Good evening to all of you. My Lord, good evening to my Lord, Honorable Justice Indira Banerjee. It is indeed a great honor and privilege to address this global conference on law and justice being inaugurated by My Lord Honorable Justice Indira Banerjee, Judge, Supreme Court of India. I'm also grateful to Dr. V.R.S. Sambat, editor of Sattakadir, Tamil Law Journal, for organizing this 2 days global conference on law and justice with a laudable object to enlighten the members of the legal fraternity on various important and interesting legal issues. I've been seeing Dr. V.R.S. Sambat past 25 years. For the past 28 long years, he has been rendering immense service to the common man, the litigants, members of the bar, and also to the institutions. By publishing all the judgments rendered by the high courts and judgments rendered by the Supreme Courts into mother tongue. With the result, he has been taking these legal principles with more clarity to the common man, the lower judiciary, and also the legal fraternity who are all practicing in the lower judiciary and also in the high court. A lawyer can become a successful lawyer provided if he possesses more clarity in thought, and that should reflect in his pleadings, and more often that should also equally reflect in the presentation of cases before the courts. If he is more clear, the more rate of success will be there in all his cases. As a matter of fact, when the high courts and the Supreme Courts are all rendering very important landmark judgments, some of the lawyers and even some of the members in the subordinate judiciary will be finding it too difficult to appreciate the settled laws. To make them more clear, this Sattakadir Tamil Law Journal has been released. By translating all the judgments of the High Court and the Supreme Courts, in a way, the endeavors and the efforts that has been taken by Dr. V.R.S. Sambat in the last 28 long years in publishing this Sattakadir Tamil Law Journal is not only helping the poor litigant, the lawyers practicing in both subordinate judiciary and the high courts, but also the institutions. The reason being, when a lawyer comes to the court with all clarity on a particular legal position, it will be more easy for the courts to render the judgments on the complex issues. Therefore, I wish him all success to continue his publication in the days to come. I wish him all success, and I request the members of the bar also to render all possible assistance to Dr. V.R.S. Sambat to continue to help the legal fraternity in bringing all the judgments of the High Court and Supreme Court to their doorsteps. Since distinguished speakers are all going to present various papers on interesting issues, I am also induced to speak on a particular topic, that is legal education in India and the role of Bar Council in India. In ancient times, teaching law was given equal importance with medicine. If we go back to Christian era, before Christian era, in Nalanda University, Veda was taught as one of the important subjects. Magic was also taught as one of the subjects. Logic was also taught. Medicine, law, maths, astronomy, and other disciplines were taught equally well without giving any importance over other subjects. Ladies and gentlemen, if we look at our freedom movement, that was led by legal luminaries, Desabandhu Chittaranjan Das, Sri Mahatma Gandhi ji, Dr. Rajendra Prasad, Sri Raja ji, Sri Motilal Nehru, Sri Jawaharlal Nehru, Sri Sardar Patel, Sri Subhash Chandra Bose, and various other legal luminaries have really worked very hard, selflessly, and ultimately taken us to the possible point from where we were able to get freedom from British ruler. However, after independence, legal education was neglected in India. Nonetheless, in late 1980s, legal education in India, I must say, underwent a great revolutionary change. When we speak about the legal education, which has undergone a revolutionary change in India, we cannot forget the contributions of Professor Dr. N.R. Madhava Menon, whom we consider as the father of modern Indian legal education. Like Dr. V.R.S. Sampath, who has been contributing his might through the Sattakadir Tamil Law Journal to the legal education in Tamil Nadu. Professor Dr. N.R. Madhava Menon's contribution also cannot be slightly ignored. I would tell you, in late 1980s, Dr. Madhava Menon has established various national law schools all over the countries. Not only national law schools in our country, but also law universities. When the law universities, almost 23 numbers, in addition to the private national law schools like Jindal, Amity International, VIT School of Law, and so many other school of law. Today we have 23 national law schools. They are producing highly talented law students with the skills of communication, with the skills of arbitration, with the skills of mediation, with the skills of language, with the skills of advocacy, etc. And they are all extremely useful to multinational companies. As a result, the multinational companies are all standing in queues to recruit all these highly talented law students when they're all going to come out from these national law schools. They're all going to these national law schools for conducting the campus law interviews. And when they're conducting the campus law interviews, on selection, the corporate law houses are offering almost salary ranging from 1 lakh to 3 lakhs to these law students, even at the beginning of their career. As a result, if I say so with all humility, the Bangalore Law School, Nalsa University in Hyderabad, and also Nalsa University in Calcutta are getting 100% placements. Consequently, no student is finally found access to go to legal profession. because, as I mentioned to you, the corporate houses are all offering remuneration, monthly remuneration ranging from rupees 1 lakh to 3 lakhs. In view of this, all the law students who are all produced by these national law schools and law universities are all being taken, hijacked by the corporate law houses. One another very interesting aspect is many of the reputed corporate law houses, when they're all going lately to these national law schools to recruit these highly talented law students from these national law schools, sometimes they are not even able to find even a single lawyer. As a result, they're all going back from the campus with empty hands without securing one single law student for them. That clearly indicates that the developments that is taking place in view of the establishment of national law schools, the legal education in India is really flourishing very well beyond any other discipline. We have been seeing that the campus interviews are also being conducted in some of the reputed engineering colleges, but the selected engineering candidates are all offered only 30,000 rupees, sometimes 40,000 rupees, sometimes 50,000 rupees, and some other time you can see 60,000 rupees. But in the case of the corporate law houses, when they are conducting the campus law interviews in these national law schools and national law universities, they are offering the highest remuneration ranging from 1 lakh to 3 lakhs rupees. Therefore, today, whatever the national law schools are producing, they are not coming to the legal profession. As a result, the bar and bench are losing the talented lawyers. When the bar is losing the talented lawyers, the impact is also there on the institutions, the bench, because the bench is also not able to find talented lawyers for elevation. In view of all these things, both the bar and the bench are wholly relying upon the government law colleges and other private law colleges, which are all producing the substandard law materials. In fact, when we talk about the government law colleges are not having sufficient infrastructure facilities like library facilities. It is not properly given. Even the lecturers and professors who are all working in the government law colleges and in some of the unrecognized private law colleges, they are not given adequate training to teach the students who are all studying in the government law colleges. We are all concerned, we are all giving more importance only to the law students, but we are not giving any importance to recruit, to train the lecturers, professors who are all working in our government law colleges and other private law colleges. I must also remind one thing herein, that in Bhopal, we have National Judicial Academy. In the National Judicial Academy, a training program has been organized to impart training to the selected High Court judges on the latest judgments given by various High Courts, Supreme Courts, and other High Courts in the world. When you come down to the state level legal education, in every state we have the state judicial academies. When the judicial academies are all set up, established in every state to impart training to the judges working in the subordinate judiciary, they are all made to learn what is the latest law development in our country, so that they will be able to shape, mold the law and the relief to the the litigants who are approaching the court. When we are concentrating on the judges by way of giving them training, we do not have any legal academies to impart training to the teachers, lecturers, professors who are all working in the government law colleges and other law colleges. Therefore, the roles of the Bar Council of India has to realize that this is the time come to them to establish some legal academies in every state, in every district, to teach and also give them proper training to the professors, lecturers working in the government law colleges and other law colleges. If you do not think to give them training, what will happen? And I must say, there will be two classes of lawyers. A lawyer or the law students hailing from the national law schools and the law universities will be forming one class. They will be always given a red carpet welcome wherever they go. The reason being because the law students who are all coming out of the national law schools and the national law universities are all given the better training, better education. With the result, they're all coming with a specialized skills on advocacy, the specialized skill on mediation, arbitration, etc. On the other hand, the law students who are all hailing from the local government law colleges are coming just like that without having anything for preparing for their cases. Now, the law students who are hailing from the government law colleges are all rejected as inferior qualities. With the result, they are not able to compete with the law students who are all coming from the national law schools and law universities. This situation has to be taken into account by the Bar Council of India. The reason being, the Advocates Act has given enormous responsibility to the Bar Council of India to prepare the curriculum and also to set right the legal education in India. Therefore, the Bar Council of India has to step in to remove this inequality between these two class of students, two class of lawyers, failing which we will not be able to, the society, the bar, the bench will not be able to have pleasant days in the days to come. Friends, I must also tell you one more thing. Legal education in India has gone, in my assessment, to the top of the height. If I tell you one very interesting and important aspect, you will also agree with me. Today, the science and technology has become the basic subjects for the law students to acquire law degree. We have been seeing the national law schools. There is one more higher steps which has been set up by the IIT Kharagpur in West Bengal. The IIT Kharagpur, West Bengal, has come out with very innovative scheme. With that, they have established a different law school within the IIT Kharagpur campus. Similar pattern has been followed by the Delhi law schools. And one more, the similar pattern has been followed by one more university, namely the Kanpur Law School in UP. Today, friends, the IIT Kanpur National Law School set up in Kanpur, set up in the Kharagpur. The another law school set up in the Delhi Law School. The third law school set up in Nagpur in UP. They have a very, very interesting pattern of admission. If I tell you, it will be a stunning and a surprising fact. If a student wants to acquire law from these national law schools, these national law schools are all prescribing a peculiar kind of eligibility criteria. A person who is having B.Tech engineering degree alone will be able to apply to these national law schools in the IIT Kharagpur National Law Schools and the national law schools that is in the Delhi National Law Schools and also the Kanpur National Law Schools. So to become a lawyer today, one has to have a B.Tech degree. The reason being, today the science and technology has become very basic aspect, basic foundation for a lawyer to learn so many good things. For example, a person who is coming out from these 3 national law schools, they will be able to know the technological defects far better than the conventional lawyers like K.K. Venugopal, the Arima Sundaram, and Sodi Sorabji. When these people are drafting the petitions and they are presenting their argument before the specialized forums like the telecom regulatory authorities or the gas regulatory authorities or before the cyber law, they will be able to surpass all the conventional lawyers. Today, another very interesting, important aspect is when the B.Tech degree holders are all admitted in these national law schools, after completing the course, they are not going to join the engineering field. They are all joining only the legal profession. As a result, there is going to be a vast difference between the lawyers, the conventional lawyers, and the lawyers who are all produced by the national law school today. Therefore, the Bar Council of India has to realize that now the time has come to them to set up a uniform curriculum that has to meet the requirement of today's lawyer. Whether a lawyer is coming from the national law schools, whether a lawyer is coming from the ordinary government law college from Tamil Nadu, from Madurai, or from any other place, they will be in a position to meet the requirement of the society. Only then the Bar Council, we can accept the role of the Bar Council has been performed very well. Friends, I do not want to take more time. I know that many speakers are all waiting with their papers. If time permits, I would tell only one important aspect, that in US, only 90% of the lawyers, 90% of the lawyers are not appearing before the courts. Only 10% of the lawyers are going before the court. A similar style of advocacy, similar style of practice is going to also come to our India. I tell you one, in another 10 years' time, lesser and lesser number of lawyers are going to appear before the court. The reason being, today, as I mentioned to you, all the corporate houses are all standing up in line to take over, to hijack all the law students into their fold. Once they are able to take over all the law students from the law schools, we are left with only the students hailing from the government law colleges. Therefore, I fervently request the Bar Council of India, who are all saddened with the responsibility by the Advocate Act to give proper training. Once the Bar Council of India comes forward with some scheme to give a proper and better training along with changing the curriculum, I hope we will not be able to see any inequality among the lawyers. Therefore, I congratulating Dr. Sambat for having given me an opportunity. I thank him for organizing such a wonderful global conference on law and justice. Thank you very much.
Thank you, Honorable Judge. You've given a wonderful speech for the present day. I am very happy. The Bar Council members, Mr. Vidudara is there, Mr. Saravanan is there. They will take some note of that speech and take it to the Tamil Nadu Bar Council to propose to the All India Bar Council to many things. Now I am requesting the Honorable Justice Madam Indira Banerjee will inaugurate this conference and deliver his inaugural address.
Good evening, all of you. And of course, my former colleague, Justice Raja, across there. It's a pleasure for me to be here this evening. I feel privileged to be invited by Sattakadir Tamil Law Journal to inaugurate the 28th Sattakadir Global Conference on Law and Justice and to deliver the inaugural address. I have very happy memories of my brief stay of 16 months in Chennai as Chief Justice of Madras High Court. And for the benefit of my colleague, Justice Raja, you can see what I have here at my working place. The memento which I carry from Madras High Court, the model of Madras High Court. The central theme of this global conference is the concept of law and justice and the extent to which they serve to guarantee individual rights and the extent to which they restrict and or limit the exercise of individual rights. What is justice? What exactly is justice? Generally speaking, justice is an ideal. It represents that which is right and just. Justice basically means being just, impartial, fair, and right. What is just may depend on the context, but its requirement is essential to the idea of justice. One school of jurisprudence believes that justice means the implementation of religious laws. On the other hand, the modern schools of jurisprudence say justice means the implementation of concepts like equality and liberty. In either case, justice means enforcement of what the law perceives to be right, what the law perceives. According to Samant, can we have the microphones off, please? It's a little disturbing. Thank you. According to Samant, bodies of principles that the tribunals recognize and apply while administering justice. It's a body of rules. Roscoe Pound defines laws to mean principles that tribunals recognize and enforce. In the modern context, justice basically means recognition and implementation of laws made by legislative bodies. The responsibility of interpretation of the laws lies largely on judicial bodies. When we talk of delivery of justice, it is not the courts of law alone which deliver justice, as we all know. It is the legislative bodies which enact the law, the executive which executes the law, and the judiciary which interprets the law. Professor Deborah wrote in her book, In the Interests of Justice, Reforming Legal Profession, which was published in 2000, invites every person seriously interested in law to think about relationships between law and justice as they might exist in the years ahead. It is, however, extremely difficult to actually make predictions for the future because of rapid changes in the social and in other spheres. When we think of the future, we have to delve into a historical analysis of how we have arrived at our present stage. This is of importance in contemplating the future. Not only our country, but the whole country will be more intensively governed by law and legal institutions in the future, in this century, in future centuries, than in the past. In today's world, any talk of justice is meaningless unless it takes into consideration the concepts of equality and liberty, and also posits specific and definite legal rules and legal institutions. When the law and the institutions through which justice is delivered are specified, political controversy is almost immediately encountered. Any serious discussion of justice has to address politically issues concerning specific policy matters. In a democracy, as we all know, almost any legislation is preceded by discussions and deliberations. If the opposition is opposed to a particular law, they vehemently oppose the law, and it is only after a lot of discussions that law is actually enacted. When I speak of law, liberty, equality, and justice, I really refer to the laws as known to a parliamentary democracy, because in India, we have a parliamentary democracy. Of course, even totalitarian regimes, even despotic states enact and pass laws. It's not as if the passing of laws is something which is a distinguishable feature of a democracy alone. But what distinguishes a law passed by a democratic polity is that in a democracy, importance is given to individual rights, and the balancing of individual rights and individual freedom with the concept of public good, with the concept of common good. Therefore, the system of laws in a democracy postulates paramount importance of individual liberty and freedom. It seeks to harmonize the claims of individual liberty with the claims of public good. There is another distinction between the laws in a parliamentary democracy and the laws passed by a totalitarian state, and that is what I have referred to a little earlier. Parliamentary democracy postulates a popularly elected elected legislative bodies, and the government of the day is formed by the party which is in majority in the legislature. In a parliamentary democracy, legislation is preceded by discussion and deliberations. It is open to the party in opposition to criticize the proposal to enact a law if it is opposed to it. Moreover, Even after a law is passed, its validity is tested in courts. The quest for justice is challenging because it is too vast. Way back in the 4th century BC, Aristotle tried to make a distinction between particular justice and universal justice. He distinguished between distributive justice and corrective justice. Distributive justice is based on the principle that there should be equal distribution among equals. Corrective justice, on the other hand, seeks to restore equality when this has been disturbed by some wrongdoing. The principle of equal distribution amongst equals, advocated by Aristotle, also has its own weaknesses. What is to be distributed equally amongst equals? Perhaps it is honors, it is money. Who are the equals? They are persons who, according to Aristotle, had an equal share in the constitution. The formula was not very precise. But then what was the criteria of equal? Who was to decide equality? Were unequal cases to be decided unequally? Were unequals to be treated differently? What would be the criteria for differential treatment? Another problem is that in giving equal treatment, unequals may be treated equally, and that may widen or create inequality. For example, if two contracting parties were to be treated on an equal footing, when one contractee was a powerful corporate body or a statutory body and the other an individual, perhaps there might be some injustice on the weaker party. Therefore, the concept is equals have to be treated equally. Unequals may be treated unequally. But in making the determination, can the determination be done arbitrarily? It has to be based on some rational principles, on some rational basis. In India, we have a written constitution. On 26 November 1949, India adopted its constitution. The principles on which the constitution is based are beautifully summarized in its preamble. The people of India gave to themselves a constitution. They constituted India into a sovereign democratic republic. By the 42nd Amendment, the words secular and socialist were added. What does this constitution promise to all its people? This constitution which the people have given to themselves promises to secure to all justice, political, economic, and social. It's a justice-oriented constitution. It guarantees to all liberty of thought, expression, belief, faith, and worship. It guarantees equality of status and of opportunity, and to promote amongst all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. The word integrity was again not there when the Constitution was originally enacted. It was later incorporated into the Constitution by the 42nd Amendment Act. And by integrity, we mean the honesty, the value system on which the Constitution is based, and of course, the oneness of the country. We have been talking about law. Now, theoretically, it is possible, it may not be incoherent to have justice without law. Because what is law is a set of rules and regulations which govern human conduct. On the other hand, justice is securing to a person what is rightfully due to that person. As stated earlier, a little earlier, who is responsible for doing justice? Is it the state alone? No, even individuals. Individuals do a lot of justice and they do a lot of injustice. What about cases of domestic violence, where a woman is battered in her home? The injustice is perpetrated by a member of the society. What about social ostracism for no rhyme or reason? Injustice is perpetrated by members of the society. Similarly, a lot of justice is also done by the members of the society. In a polity which is governed by the rule of law, it is presumed that the laws enhance justice, the laws are just and fair. But then sometimes laws are criticized as arbitrary, and there are controversies, there are debates about what is just and what is unjust. Say, for example, when we deal with the community, when we deal with the country, we have to frame certain laws, and they are applied to certain people as a class. But what about individuals whose right to equality gets affected? Let us say when there is reservation for a certain class of people, and even those who do not really need the benefit of reservation get the benefit of that reservation. But there may be others who are left out of that class, who may really need the benefit of reservation, but may not be able to get the reservation. His right to equality may be affected. What can be unjust, more unjust, than a person being denied the freedom of speech, the freedom of expression? Every person has the right to speak. What can be more humiliating than unequal treatment? Now, there are different forms of justice. Today we talk of justice for the child, we talk of child rights. We talk of gender justice. We talk of different kinds of justice. It is the duty of the courts, the tribunals, to interpret the rules which govern human behavior. That is what we call the law. What are the basic sources of law? We have the customary law, we have the statutory law, we have law which emanates from a contract by agreement from the parties. Very importantly, we have the law which is laid down by the courts in the form of judicial precedents, the judicial value, the legal value of law as interpreted by the courts. Now, when the courts interpret the law, the courts obviously have a justice-oriented approach. But then in our country, there are also some limitations to this justice-oriented approach, because we have a system of separation of powers where we have the legislature which enacts the law, the executive which executes the law, and the judiciary which interprets the law and decides disputes. The will, the intent of the legislature always has to be respected. But then sometimes the language which is used by the legislature may be capable of more than one meaning, in which case the court has to give an interpretation. And in interpreting statutes, there are certain norms. When the language is plain and simple, the courts should give meaning to the plain and simple language of the statute. But then very often, as it is said, what appears to be plain and simple may not really be that plain and simple. And there may be a case where giving a statute an interpretation as per its plain meaning may result in injustice. Now, it is generally presumed that it could not be the intent of legislature to enact a law which should be unjust to the people, and particularly in a country like India, where we are governed by the fundamental rights, and the legislature is restricted to enacting laws which do not violate any fundamental rights unless the law is entitled to the protections of one of the protections of 31A, 31B, or 31C. Thus, if we find that the result of an interpretation is totally arbitrary, the court may give an interpretation which makes the law, brings the law into conformity with the fundamental rights to equality, liberty, and the like. We have a lot of speakers ahead. The topic of law and justice in this country is such that one could just go on and on and on speaking for hours. But much as I would like to say a lot, I think I should now stop to make way for the others who will be presenting papers in the evening. I wish the Global Conference on Law and Justice a success, and I'm sure all of us will benefit immensely from the conference. Just before I conclude, just a few words about the Sattakadir Law Journal, which has been publishing judgments in the vernacular in Tamil for the last 28 years. Of course, from my experience, I find that most of the Tamilians, at least most of the Tamilians I've encountered, are well educated. They understand English, they speak English, but still there is a difference. In our country, the legal system developed at a time when we were ruled by the British. In fact, the Madras High Court was founded in 1862. All the chartered high courts were established when India was under British rule. Of these courts is English. And then even today, we have a system of shifting judges from one court to the other. Now, I may have learnt a few words of Tamil, a few sentences of Tamil when I was in Chennai, but it would have been very difficult for me to deliver a judgment in Tamil or to understand a judgment in Tamil. So this is the reason why we have a common lingua. English has become a common lingua franca because people from other states may not be able to understand the language, and it's been going on. Now, it is much easier to appreciate and understand the writing which is there in one's own vernacular. One may understand a foreign language. So whether it is the lawyers, whether it is the litigants, they may be able to understand a judgment which is rendered in English, written in English, but it would be far easier for them to appreciate the judgment and understand the niceties, the finer points of the judgment when that judgment is translated into the vernacular. And I think by translating judgments of the Supreme Court, judgments of the High Court into Tamil, the Sattakadir Law Journal is doing a great service towards the cause of justice. It hardly need be mentioned that the judges have an important role to play. The lawyers also have a very important role to play. Justice begins at the grassroots level, at the level of the subordinate courts, the district courts, then the High Court, so on and so forth. And the best judgments come when there are good arguments from the lawyers, and good arguments can come from lawyers if they really understand the precedents well enough. Thank you very much. Thank you for giving me the opportunity to be here.
Thank you, Honorable Justice Madam. You've given a very detailed speech on law and justice and also the Sattakadir. It is a great pride for us to listen from your mouth about Sattakadir services. You participated in our Silver Jubilee celebrations. It is a wonderful opportunity for us to see our Lordship to participate again in this wonderful conference. Thank you. Thank you, Madam. Now I'm requesting Honorable Justice Gopal Sriram from Malaysia, is a former judge of Federal Court. Sir.
Good evening. A very good evening to all my brothers and sisters of the Indian judiciary and to the lawyers, advocates of the Indian bar. I want to first of all thank Dr. V.R.S. Sampath for affording me this honor and privilege of participating in this event. I don't know where Sampath finds the energy to regularly organize these events. I have been avoiding his invitations for the last 5 years, but I think today he cornered me and made sure that I was free to attend and speak at this event. My speech will be very short because I will be addressing you on the issue of law and justice from the Malaysian perspective. Malaysia is a multiracial, multi-religious, and multicultural country. We also have a written constitution. And like the Indian constitution, we have concepts which have been taken from a number of sources. Our equality provision in Article 8.1 very closely resembles your Article 14. Our Article 5 very closely resembles your Article 21, though yours speaks of procedure according to law. Ours was taken from the Irish Constitution of 1909, which speaks of life and personal liberty. The tensions between the various arms of government in any democratic society arise because it is a democracy. And what is a democracy was actually defined by Lord Steyn in the leading case of the state of Mauritius against Koirati. He says this, he says democracy involves a number of ideas or number of principles. First, the right of the people to elect the government to govern them. Second, an independent judiciary. And third, a chapter on fundamental rights which are enforceable in courts. And the resultant tension between the state, that is the executive and legislative arm on the one hand, and the judiciary on the other hand, when it comes to the enforcement of these rights. And this is the area in which I would like to concentrate in the Malaysian context. Our courts have said on numerous occasions that in our country, Parliament is not sovereign. In our country, the Constitution is sovereign. And this is how it begins. We have what is called Merdeka Day. That is our Independence Day, which is called Merdeka Day, which was the 31st of August, 1957. And Article 4.1 says this, that this Constitution is the supreme law of the Federation, and any law passed after Merdeka Day, which is inconsistent with this Constitution, is void to the extent of the inconsistency. Now, you as Indian lawyers and judges, my brothers and sisters, will immediately recognize that the Vairis article here in 4.1 is very different from your Vairis article in 13(2), because your Vairis article only renders laws invalid when they conflict with part 3 of your constitution. In our constitution, the wording is much wider. Therefore, in a series of judgments, one of which I was privileged to deliver, we held that unlike India, where the basic structure doctrine is limited only to amending acts, in our country, any act, including an act amending the Constitution, would be struck down by the courts if it is inconsistent with the basic structure of the Constitution. The second, or rather the third aspect which I'd like to deal with is this. The amending power, the amending power of in your constitution. I'm sorry, somebody has to shut up because somebody is intervening. If you could please turn off the mic. Thank you. You see, in your constitution, your amending article speaks of a constituent power to amend. In our constitution, our article 159 does not contain the words constituent power. It merely says that any provision of this constitution may be amended by federal law, and federal law by definition means an act passed by Parliament. The tensions which have arisen and the contradictions which have arisen among different members of the judiciary is by reason of a conflict of views. There is a group that still believes that Parliament is supreme. Obviously, they don't know, they were absent on the day they were teaching constitutional law in class. But in our country, Parliament is not sovereign. As a result of which, because of these conflicts, there have now arisen two lines of thought in our attempt to obtain some form of civilized justice in the public law system. There is a set of views which say that if Parliament enacts a law and it conflicts with any of the articles in the Constitution, or if it conflicts with the basic structure of the Constitution, then the court would be empowered to strike it down. Since law and justice are actually intangible concepts, one has to relate them to concrete cases. And it is only through discussion of concrete cases that one can really see the way in which law and justice interact. And for that reason, I'm selecting 3 cases from my jurisdiction to show how, very quickly, how we have dealt with the problem. The first is a case called Sivarasa against the government of Malaysia. Mr. Sivarasa was an advocate and solicitor of the High Court of Malaya. He wanted to stand for elections and be elected as a member of the Bar Council. He happened to be an active member of a political party. There is a provision in the Legal Profession Act, which is the equivalent of your Advocates Act, which says that the Bar Council, that a member of the Bar Council shall not be a member or an active member of a political party. Mr. Sivarasa was an active member of a political party called the Justice Party. The Pakatan, that's right, the Party Keadilan, which is Justice Party. He then applied to stand for he put forward his name to be nominated for election to the Bar Council. His nomination was rejected. He then brought an action against the Bar Council and the government for a declaration that the section which forbids the active politicians from seeking election to serve on the council, that means the executive body of the Bar Council, is unconstitutional. Ultra vires is his right to be a member of an association under Article 10 of our Constitution, which is the same as your Article 19. So here is the right to belong to an association. So we sat and we held, number one, we set out the principles which govern constitutional interpretation, which hadn't been done until then. Then the next thing we did was we said that any restriction of a right given under clause 10.1, for example, clause 10.1a speaks of freedom of speech, whereas clause 10.2 speaks of the right of Parliament to impose restrictions. Your Article 19 uses the word reasonable restrictions. Our Article 10 bracket 2 does not use the word reasonable for historical reasons. So it just says restrictions that may be imposed by Parliament, but the exempting areas are the same: public order, security of the Federation, etc. So these are the restricting or the qualifying, the derogating power, the power of derogation on the part of Parliament. So we held that because of Article 8.1, the interaction between Article 8.1, which is the equality provision, the equal protection provision, we held that the equal protection provision did not allow government to pass a law which was disproportionate. In other words, you can impose a restriction, but that restriction must meet the doctrine of proportionality, must be proportionate to the harm it seeks to achieve. And in that way, we limited Parliament's right. But the ultimate decision we held that it was a legitimate, it was within the legitimate scope of Parliament's plenary authority to impose a restriction on politicians becoming members of the Bar Council, because traditionally Bar Councils have always been apolitical. They are professional bodies, and therefore for that reason, there was a reasonable classification for excluding the active politicians from becoming members of the Bar Council. So in that case, principles were established, but the appellant failed. Nevertheless, in the case that immediately shortly followed after that, one of our very powerful judges, Justice Zainul Ali, in a case called Semini Jaya, held that Parliament could not interfere with the judicial power of the Federation by requiring the court to rubber stamp a decision. The actual point that arose for decision is very simple. The Land Acquisition Act 1960 of Malaya provides for the acquisition of land and that the quantum of compensation is to be decided by a court comprising of a judge and two valuers, two assessors. In an amendment made in the 1980s, the judge was absolutely mandated to accept the value or the decision made by the assessors. The appellant argued, Semini Jaya argued, that conflicted with the judicial power of the Federation, because the duty of a judge was to act independently and not upon the dictate of a third person. And that was the fundamental basis of the judicial power. For that reason, a unanimous bench of 5 justices of the Federal Court held that the provision was unconstitutional. And in the course of her judgment, Justice Zainul Ali said that the amendment to the Federal Constitution, which had been passed in 1988, which took away the words judicial power from Article 121 of our Constitution, which vests judicial power in 2 high courts, and in the one in Malaya and one in Sabah and Sarawak, and in the subordinate courts. The attempt to remove the words judicial power by Parliament in 1988 was futile, and that the courts would not entertain any rubber stamping process. So the challenge succeeded, and it was held that the law was ultra vires, the doctrine of separation of powers. Now, if you look at the Indian Constitution or any constitution which is founded along Westminster lines, what Lord Diplock referred to as Westminster lines in Hinds and the Queen in 1976, you will not find any specific provision which says that there shall be separation of powers. But nevertheless, if one examines the way in which our constitutions are structured, the Caribbean constitutions, the Indian constitution, some of the East African constitutions have been structured. They all can be seen to incorporate the doctrine of separation of powers. And the Privy Council in 1967, in an appeal from the Supreme Court of Ceylon, in a case called Lianaji against the Queen, held that although the Ceylon Constitution did not expressly use the words judicial power in it, nevertheless, the way in which the Constitution was constructed, read into it, or housed in it, better way of putting it is to housed in it the doctrine of separation of powers. So applying that principle, the provision in the Land Acquisition Act, which made the court a mere rubber stamp, was struck down. The third and probably the most important decision, concrete case, which one can see, would be the case of Indira Gandhi against the registrar of Muslims in the state of Perak, the Department of Islamic Affairs, Registrar Department of Islamic Affairs, Perak. In Malaysia, we have a separate provision in the Constitution by way of amendment, provision called 121A, which says that the Sharia court's jurisdiction shall not be exercised by the High Court or the other courts. Beg your pardon. The importance of that came up for decision in Indira Gandhi. Indira Gandhi was a Hindu lady. Her husband was a Hindu man. They underwent a civil form of marriage under the Law Reform Marriage and Divorce Act, 1976. The result of that marriage was that, one, it became monogamous, and number two, it imposed certain duties on the parties to the marriage. The husband unilaterally converted himself into Islam. He then converted two children to Islam, though they were infants. He then kidnapped one of them and took them away. Indira Gandhi brought an action to get her daughter back from the husband. Under the Law Reform Act, Marriage Act, once one party converts to Islam, the marriage is automatically dissolved. So she was able to get a decree of divorce, but she couldn't get her child back. So she went to the ordinary courts to seek an order against the husband and against, more importantly, she sought judicial review against the Department of Religious Affairs in a state, Perak. Perak is a state, just like Tamil Nadu is a state, or Gujarat is a state. Perak is a state in the Federation of Malaysia. So she brought this judicial review. The High Court held that it had no jurisdiction to entertain the application because the husband was a Muslim, and the matter was, therefore, the subject matter, whether the child could be recovered from the husband, was strictly a matter for Muslim law to decide, for Islamic law to decide, and therefore it should go to the Sharia court. But the Sharia courts had no jurisdiction over a non-Muslim. The Court of Appeal affirmed that decision. So Indira Gandhi then appealed to the federal court by leave. And Justice Zainun Ali, again, speaking for a bench of 5, held that One, judicial review was a part of the basic structure of the Constitution. And it is interesting to note that she used the decision of the Indian Supreme Court in Minerva Mills against Union of India to obtain that result. Second, she said that because of Sivarasa and applying Keshavaranda Bharati, the basic structure doctrine was part of our Constitution. Third, she held that the registrar in the state, the law giving the power in the registrar of Islamic affairs of the state of Perak could not prevent the civil courts from looking into the legality of what the husband did. And in the upshot, she ruled that because of the supremacy of the Constitution, and because of the doctrine of separation of powers, and because of the supremacy of the power of judicial review, the ordinary courts had jurisdiction. And they granted certiorari and quashed the decision of the Department of Religious Affairs. That's a far-reaching decision. Now, almost immediately after she gave her judgment, the constitutional, what I call the constitutional wrecking crew, got into its act. And there's been, unfortunately, since then, a number of decisions in which they have tried to water down the effect of Simini Jaya and Indira Gandhi. But fortunately, in 2018, 2019, a 9-man bench of the federal court, led by the then Chief Justice Richard Malanjum, held that Indira Gandhi and Simini Jaya were rightly decided, and that Sivarasa was rightly decided. And then that is now today the present state of the law. But as I said, the constitutional wrecking crew is still not down tools yet. It is still extremely active, and in a very recent decision delivered earlier this year, there was a challenge mounted to the mandatory death penalty in the Dangerous Drugs Act and the Penal Code, and the Penal Code. Our Penal Code is the same as the Indian Penal Code. So we have mounted there was a challenge mounted against the constitutionality of these statutes, and an ill-informed majority of the federal court held, applying a decision from Australia, that Parliament had the right to impose mandatory death penalty. Now, before I close, I would like to say this. In Australia, there is no chapter on fundamental rights in their constitution. So to try to apply decisions given in respect of a constitution which does not have fundamental rights to a constitution which has a chapter on fundamental rights. Our constitution has a part 2, which resembles very closely your part 3. And so to apply decisions of a court delivering a judgment on separation of powers in a constitution which does not have a chapter on fundamental rights to one that does is, of course, like applying apples to oranges, comparing apples to oranges. But then by 8-1, there was a dissenting judgment by Justice Nalini Padmanabhan, but the majority held that the 8 judges held that the law which mandated the death penalty is valid. Of course, the bar has not been keeping quiet. There's a challenge now mounted just 2 weeks ago to challenge the correctness of that decision. But because of this COVID virus, the hearings cannot be conducted. So to sum up, while we all agree that law and justice must seek a common goal, that goal must be in relation to concrete cases, whether it be in private law or public law. I've chosen the public law examples because those resemble the Indian experience. And I think, largely addressing an Indian audience. So except for thanking you all for being very patient and listening to me, and I want to again thank Dr. Sampath and congratulate him for his efforts. And it's not easy to do a translation of a judgment from English to any other language. As Mr. Palkiwala once said, Nani Palkiwala once said, you cannot think in extreme terms in English. So it took the English nearly 300 years to give up Latin and Anglo-French and come to English, to the English language. We are very lucky, very fortunate, because we are all English speaking, and we have a common, not only language, but we have the common law which binds us all. And I look forward again to participating in future events. Very good evening to you. Because of the time difference, it is now 9:30 in Malaysia. It's 7 o'clock your time, but it's 9:30 here. So with your permission, I'd like to excuse myself from this event. Thank you very much.
Thank you, Honorable Judge. Given a wonderful speech to compare Malaysia, Australia, India, and a very detailed explanation about the various judgment and also how the law and justice prevailing in different countries. Thank you. I'm requesting Honorable Justice S. Vimala to present a speech. I'm requesting the speaker to maintain the time limit. Thank you. I'm inviting Honorable Justice Vimala. Suchal, இது unmute பண்ணுங்க உங்க மைக்க. Unmute. அந்த ஒரு okay.
Yes, sir.
Okay.
At the outset, let me thank Dr. V.R.S. Sampath for having organized this global meet, and I record my special appreciation for him for the love he is showing towards the mother tongue by publishing Sattakadir. Good evening to all my brothers and sisters from all walks of life. The time given by Dr. V.R.S. Sampath would permit only to say this, and will not permit me to name at least a few of them. For the sake of courtesy, I will just mention Honorable Justice Raja, Honorable Justice Indra Banerjee, Honorable Justice Gopal Sriram, Honorable Justice Durai Karunakaran, and all my brothers and sisters who would be presenting in this conference. The topic is very an astonishing topic, but an interesting topic. All men and women are born free and equal. As human beings, they are born with the right to liberty, right to life and equality. As all are born equal, nobody has got a right to cause harm to the rights of others. The state protects their rights through policing. When there is a violation of right, people are tempted to seek justice. Justice is the first promise of the Constitution. Justice is the greatest interest of man on the earth. It is the ligament which holds the civilized beings and the civilized nations together. Wherever her temple stands, and so long as it is duly honored, there is a foundation for greater and general security, greater happiness, and the progress of the society as such. When justice is done, it brings joy to the righteous person and terror to the evildoer. Speedy justice is the component of social justice, and delayed justice is the defeated justice. Therefore, the extent to which the investigation is done with quality and speed determines the quality of criminal justice. Criminal administration means the treatment of criminal by law enforcement authorities as well as by the justice dispensing authorities. Criminal justice is important because it is a system that includes law enforcement, court, prisons, counseling services, and a number of other organizations and agencies that people come into contact on a daily basis. In order to make sure that the criminal justice system does not fail and subsequently lead to private retribution, we have to fix where is the flaw. Let us consider what is the role of police. Let me quote Sidney Sheldon. He speaks about the role of police. My heroes are those who risk their life every day to protect our world and make it a better place. Police firefighters, and members of the armed forces. According to him, it is the police who works for a better place for all of us. What is their personal life? Police officers put the badge on every morning, not knowing for sure if they will come home at night to take it out. This is their poignant personal life. Then when such is the circumstances, what is the mood of the people? It is spoken about by Winston Churchill when he says, the mood and temper of the public in regard to treatment of crime and criminal is one of the most unfailing tests of the civilization of any country. What is the status of criminal justice? There are 63% increase in regard to cognizable crimes, and in respect of cognizable crimes under the special law, the increase is 73%. The escalation of crime speaks for itself on the state of criminal justice system in this country. It is for this reason that it is important to look into the two facets of criminal justice, namely the police and judiciary. And once again, it is my duty to congratulate Dr. V.R.S. Sampath for having chosen this very important topic. By and large, people are losing confidence in the criminal justice system, especially when the victims feel ignored and they are crying for attention itself and if not for justice. One pathetic aspect of criminal justice administration in India is unduly large number of under trial prisoners languishing in jail. The Supreme Court of India in the case of Ornate Singh said this: we believe that no arrest should be made only because the offense is non-bailable and cognizable, and therefore lawful for the police officers to arrest. The existence of power to arrest is one thing, and the justification for the exercise of power to arrest is another thing. Meaning thereby that just because there is a power, there is no need to effect arrest because the personal liberty is so important. You may be surprised to see the report of the National Police Commission when it accepts that many arrests are unjustifiable. The National Police Commission in its third report suggested by and large that nearly 60% of the arrests are either unnecessary or unjustified, and that such unjustified police action accounted for 43.2% of expenditure of jails. Then the question is whether the law and justice remain intact, remain inseparable, or they are totally two different things. We always assume that both are synonymous. Then what is the quality of justice? Is the justice in accordance with the law? Is justice tempered with mercy, or the larger questions to be considered? The advocates always claim that it is an uncomfortable task for them to convince their litigants that the law and justice are not necessarily the same thing. People of late tempted to believe that the police have become the judges and the media, especially the electronic, has started behaving like a court. What is the reason behind this? The Police Act of 1861 was legislated when the first War of Independence was launched in India, that is Indian Mutiny of 1857. The colonial rulers were not interested in establishing people-friendly police that is naturally subject to their wish at that point of time to conquer India. Therefore, naturally, the act is totally subservient to the executive alone and remains unaccountable to the people. The same Police Act is continuing even today after India becoming independent in 1947 and after the adoption of the Constitution of India, it remains the same. It is quite unfortunate. Under the 7th schedule to the Constitution, the subject of police in the state government. Under Article 355 of the Constitution, it is the central government which has to ensure that the functioning of the state is in accordance with the Constitution. When the Supreme Court found out that the police is not functioning in terms of the constitutional provisions, the Honorable Supreme Court in 2006 delivered the landmark judgment, popularly known as Prakash Singh case, requiring the government to urgently kickstart police reforms. 7 directions were given. I have no time to elaborate. The important one is establishment of a state security commission to evaluate the performance of the state police and also to ensure that the state government does not exercise unwarranted influence or pressure on the police. Those police reforms have been executed only to 20 to 21%, even though there are 2 decades before the judgment was passed, and it is still a distant dream. When the rulers' police would become the people police? That is the main question that is lingering in the mind of all of us. The nature of duty that they are doing is really perplexing. It is said that they are dealing with crime scenes painted in a hell, coax a confession from a child abuser, comfort a murder victim family, then to read in the newspaper tomorrow that law enforcement is not sensitive to the rights of the criminal subject. That is the position in which they have to function. So far as workload is concerned, on an average, according to the reports, each police station is handling 1,500 cases excluding the backlog. According to United Nations suggestion, there should be 222 police officers per lakh of population, but in India, there are 144 police persons for 1 lakh people. It is ironic that the police are both the law violators and the law maintenance also. When they maintain the rule of law, it is well and good. But when they use the force or engage in summary punishment, use court surveillances, and when they stop, search and arrest citizens, they are behaving in a different way, over which the discussion should also concentrate. The main complaint against the police are fake encounters, custodial torture, and custodial death. I was really wonderstruck to read the quote by Montesquieu. I would like to share with you. Open quote. There is no crueler tyranny than that which is perpetuated under the shield of law and in the name of justice. This is how it is described by Montesquieu. The death in an encounter in the Hyderabad in a case of rape and murder, where we were astonished to see people started celebrating that extrajudicial killing or fake encounter. It is really a cause for concern that we should I do not know where we are going when people started celebrating this kind of extrajudicial killing. But my only request is that we should understand this movement of the people as the cry for speedy justice, expectation for speedy justice, and not in any other way. That is why the Honorable Supreme Court said there should be an establishment of police complaint authority at state level to inquire into the complaints against the police officers, either regarding starting from non-registration of the case or police torture or custodial death, etc. That is not done. One of the other cause for concern is that under Section 22 of the Police Act 1861, the police officer is always on duty. It is not necessary that it does not mean that all are of them working for 24 hours, but the only thing is their mindset, the mind will not be free to do anything. Call may come from any place, anywhere, anytime. Then if they have to be alert on that, their mental peace may not be there. I would like to share for the benefit of the participants, when the shoddy investigation, either due to overwork, overburden, or due to any other cause, negligence, etc., what would be the result of the justice that would be ultimately delivered? It is a case of a rape of a daughter by the father, in which the mother is the only witness. Unable to tolerate the pain, the daughter attempted to commit suicide by pouring kerosene over herself and setting her. She was admitted in a hospital. Ultimately, she succumbed to the injuries. The case came for trial. The only witness, mother, naturally turned hostile as expected. And when the case was about to end in acquittal, I recalled the doctor and asked her whether it is her duty to record the dying declaration. She said yes. Thereafter, documents were found out from the record room, and it was brought before the court, and ultimately it led to the double life sentence for the father. What I'm telling is, even a small step, small lapse in investigation lead to ultimate injustice, even in a very, very critical case. Equally, we should also appreciate the dedication with which the police is functioning. I would like to quote one example, which is a very recent example, which is a heart-touching example. One sub-inspector of police with the government railway police at Vijayawada, while on duty, receives a call that a mother is died. Mother suffered death. He was granted leave, but he did not go and attend the funeral. He asked his brother to do and showing the scene via video conferencing. You know what is the reason stated by him? He said, if I had to attend the last rites, I had to cross 4 district 40 checkposts and for 3 days. Not only that, if I attend the funeral, I have to be in quarantine for 14 days. I don't want to shirk the responsibility at this very critical moment. Therefore, I did not want to go. Touch our heart. Really, if we think that anybody would be willing to do this kind of sacrifice for public interest, nobody would be inclined to. At this scenario, it is necessary to know the step taken to reform the police force. In November 2014, Honorable Prime Minister unveiled his vision for smart police. Police which should be strict and sensitive, modern and mobile, alert and accountable, reliable and responsible, techno-savvy and trained. If this smart police is brought into place, I think India will stand first, stand out, and there is no doubt about this. What is needed is technological reforms. Technology is dictating the lifestyle. Technological reform includes modernization of the control room, fast tracking of the crime and criminal tracking network and system, pushing for national intelligence grid, and pushing for incorporation of a new technology into policing. Almost many countries in the world have already used artificial intelligence into policing wherever it is possible. The police force needs to keep pace with the changing times. Modernization of the force has become inevitable, especially in terms of cyber security, counter-terrorism, insurgency, and etc., etc. To counter terrorism, a holistic analysis of the different facets of information is necessary. The national grid that would be combining 21 sensitive database into a single one, which can be accessed by the central forces like IB, RA, CBI, DRI, etc., etc. These databases include credit cards, cell phone usage, immigration records, motor vehicle registration, income tax records, etc., etc. Such a grid is definitely going to help investigators in understanding the complete profile of a suspect. The most important thing is there must be strong relationship of mutual trust between police agencies and the communities they are serving, which is critical in maintaining public safety and effective policing. The safest information, the reliable information, truthful information should come only from a person who is willing to assist the police in the investigation. Those information would be earliest in point of time that will help the police to speed up the investigation and to investigate in the correct lines. Therefore, what is needed is a police law in terms of the Constitution of India and the functioning of the police, which is people-centric and people-friendly and the Constitution-centric also. If this is done, then there is a possibility of equal justice, speedy justice, as well as social justice to every one of them in the country. Thank you very much for the opportunity given.
Thank you, Honorable Justice Madam. Given a wonderful speech about criminal administration and police administration. It is needed today's contest. There are a lot of issues going on in different parts of Tamil Nadu and other areas. Because of your paper will be very much useful to the governmental agencies and the judicial administration to look after many things. And now I'm requesting Honorable Mr. Justice Durai Karunakaran, former Chief Justice of Supreme Court of Seychelles. He studied in Madras Law College and served in Seychelles as a Chief Justice. Now he's expecting another big post very soon. I'm inviting Honorable Justice to deliver a speech on administration of justice in judges' perspective. Sir.
Thank you. Thank you, Mr. Sambat. Honorable Ms. Justice Indra Banerjee of the Supreme Court of India, Honorable Mr. Justice Raja, Honorable Mr. Justice Gopal Sriram, Honorable Dr. Justice Vimala, esteemed multifaceted personality, Dr. V.R. Sampath, distinguished senior members of the bar, Dr. Gandhi, Mr. Viduthalai, and Ms. Nalini, dear law students. participants, ladies and gentlemen, good evening, Vanakkam, Namaste. Greetings from the Republic of Seychelles. I am delighted to be invited by Sattakadir from Chennai to deliver a short address on this global conference on law and justice. I am thankful to all of you for having given me this privilege, time, and opportunity to share with you some of my random thoughts on the topic administration of justice in judge's perspective. Please forgive me if I take the liberty of speaking my mind in this discourse without reserve, for I am no longer a sitting judge. If I am seen a bit outspoken, kindly bear with me. I do so with all my sincerity, honesty, and humility. I will begin by saying that a court of law, be it appellate or trial, superior or otherwise, in the hierarchy, should steer the law towards the administration of justice rather than the administration of the letter of the law. Herein, I use the term justice in a broad sense to include both legal as well as social justice. In a judicial perspective, these two dimensions of justice are not contradictory, but rather complementary to each other. The concept of legal justice is based on technical aspect of moral rightness, ethics, rationality, law, equity, and fairness applied in the administration of the law, whereas social justice is the concept based on social virtues that everyone deserves equal economic, political, and social rights and opportunities to develop, and so applied in the administration of justice. The primary function of the court in the administration of justice is not only to give finality to the litigations, but also to render justice at large by striking a balance between these two concepts. However, such finality, in my view, cannot and should not be given mechanically by the courts resorting to mere technicality of law just for the sake of technical conclusion of the case and to satisfy the statistical targets. In each adjudication, the court ought to ensure that all disputes, including the latent ones pertaining to the cause or matter under adjudication, are as far as possible completely, effectively, and justly brought to a logical conclusion once and for all. The good sense of the court, I believe, should always foresee the long-term ramifications of its determination on socio-political and economic well-being of the community as a whole, and also adjudicate the cause so as to prevent or control the contingent delays that could possibly proliferate in future due to multiplicity of litigations on the same cause or matter. Needless to say, prevention of potential delays with judicial foreseeability is always better than cure. Therefore, our law courts would and should adjudicate the disputes accordingly with such foreseeability and good sense in order to prevent the chronic delays that have cancerously afflicted our justice delivery system in many underdeveloped and developing countries, causing social injustice. After all, the law is simply a means to an end, that is justice. If the means to a particular case fails to yield the desired result due to procrastination because of repeated appeals, remittals, reviews, revisions, writs, and retrials that prolong over decades, then we judges have to rethink, reinvent, reinterpret, and sharpen those means, the tools, in order to eradicate the judicial delay, the enemy of justice, as Lord Lane once remarked. Hence, the courts should never hesitate, where circumstances so dictate, to adopt measures that are just and expedient to prevent the delays, procrastination, and the resultant frustration in the due administration of justice. Now then, I would simply ask, which is to be preferred, the means or the end? Alas, at times, the courts, short-sighted by the letter of the law, prefer the means over the ends, resulting in the frustration of justice. Faced with glaring injustice caused to a citizen due to procedural delays or legal technicalities in a particular case, we judges cannot adjust our spectacles on the nose and say, I quote, "Oh, there is nothing we can do about it. Why is responsible for this delay or that delay? I'm so sorry to say that my duty to expedite the trial is stalled by the strict application of the letter procedural law, which my hands are tied for that man and for nearly a decade. Justice cannot be postponed until the legislature finds time to make necessary amendments to the procedure code or until such time that man becomes too old to stand trial. What a task is set before judges. Clearly, someone has a duty to do something about this unjust situation. If the judges cannot, then who else can do something about it? In my humble view, therefore, the judges in this respect is expected to adopt a triangular approach in the administration of justice to expedite the trial or hearing of the cases they deal with. First, the judges as adjudicators, when dealing with such unduly long pending cases, should bear in mind that the paramount consideration in any adjudication is to serve not only legal justice, but more importantly, justice in good time, that is, the demand of social justice. Secondly, the judges are supervisors of overall proceedings of those cases before them, monitor the timely input, performance, cooperation, and coordination of each and every stakeholder involved in the process and ensure swift progress of the trial or hearing. And thirdly, judges, as a protector of the rights of the citizens, have to ensure that those rights enshrined in the Constitution, statutes, and the international instruments, including right to hearing within a reasonable time, are properly respected, suitably applied, and effectively implemented by the authorities and protect the rights of those individuals at all costs. Having said that, being apex in the judicial hierarchy, we are final and so set authorities as case law for others to follow. We are final not because we are always right. We are always right because we are final. The privilege of finality accorded to our decisions is the epitome of the trust and confidence our people have placed on us as justices of the highest order, hoping that we would meet their expectations in the administration of justice. Needless to say, they have conferred that privilege on us with an implied condition that we would secure the freedoms, rights, and liberties of all the people, not only of those who appear before us as appellants or respondents, seeking remedies for their individual grievances. Justice is an indivisible word, and justice is rooted in public confidence. If you want to administer it, enjoy it, and fight for it, we must be prepared to extend it equally to everyone, whether he or she be a prisoner or a law-abiding citizen or a powerful politician or a responsible journalist going about his daily business. In deciding cases, obviously, judges should look at the big picture and face the ground realities. We cannot isolate ourselves from the fabric of contemporary society and live in a legal utopia cut off from the rest of the world. We cannot and should not lock ourselves in our ivory towers and turn a blind eye to the plight of the weakest, the voiceless, and the defenseless in this country. And we should take into account the emergence of certain crimes that threaten social morality, unity, and the very existence of us as a nation. After all, judges are but agents of society who enforce the social will that manifests itself in the law. Yet, they remain very much a part of the society we serve as we sit on the judgment seat and pass judgments on our fellow citizens. However, the sensitivities of the community are largely invisible, useless, and unrepresented in our courtrooms, while vociferous lawyers argue their cases to protect the interest of their clients only. In striking a fine balance between the interest of the individual on the one hand and the larger interest of the community on the other, one should never miss the forest for the trees. Having said that, I thank Mr. Sampath for this great contribution he is doing to the Tamil language. Tamilukkum amudenru per, அந்த Tamil இன்ப Tamil எங்கள் உயிருக்கு நேர். I am very grateful to Mr. Dr. Sampath for maintaining this Sattakadir and bringing our Tamil closer to the heart of every Tamilian in Tamil Nadu. Thank you very much for listening to me.
Thank you, Honorable Justice. You've given a wonderful speech about the judges' role on judicial administration and judges' activities, judges' involvement on public activities, many other things you told to the Indian scenario as well as international scenario. It will be useful for our judiciary to know more about the international situation. Thank you. I am requesting Mr. A. Sankaran, full-time member, Tamil Nadu Official Language Commission, Government of Tamil Nadu, to deliver his paper, Law, Books and Journals in State Official Language. I am requesting everyone maintain their time limit. I am requesting Mr. Sankaran. Hello, Mr. Sankaran.
Yes.
Yes. Okay, you can switch on the mic.
Yes. Respected dignitaries, as
We are unable to see your face.
start video.
You switch up. Yes.
Access கொடுங்க.
What is the name you given?
Access.
Yes, that's yes. What is the name?
Usha.
Okay, access already allowed. Okay. Yes.
Respected dignitaries,
Yeah.
as President Mandela once said, if you talk to a man in a language he understands, that goes to his head. If you talk to him in his language, that goes to his heart. Considering the importance of this meeting, that has to go reach the hearts, I shall continue my speech in Tamil.
Sir, you have to switch on your camera, sir. Camera, be given a permission. Yes, now okay. Yes, again you switch off.
Okay.
Can you switch on your camera? There is a little visual on camera. You have to. Yes. That is again switch off. Mic is okay. Now, oh, still you are not. Yes. Okay. Okay. Yes. Now okay.
Yes, I sought permission from all the lordship. பெரும் மதிப்பிற்கும் மரியாதைக்கும் உரிய மாண்புமிகு உச்ச நீதிமன்ற, உயர் நீதிமன்ற நீதியரசர்களே, ஆண்டோர்களே, சான்றோர்களே, இனிய நண்பர் டாக்டர் சம்பத் அவர்களே, நண்பர்களே, தமிழக அரசின் ஆட்சி மொழியான தமிழில் சட்ட புத்தகங்கள் மற்றும் சட்ட பத்திரிகைகள் குறித்து பேசுவதற்கு முன்பு இதன் தொடர்பான சில பல சங்கதிகளையும் பதிவு செய்ய விரும்புகிறேன். சொல்வேந்தர் சுக்கி சிவம் அவர்கள் ஒரு செய்தியிலே சொன்னார்கள், ஆங்கிலேயர் ஆண்ட காலத்திலே ஒரு நாள் வயதான பெரியவாள் ஒருவர் 10 வயதும் நிரம்பாத சின்னஞ்சிறு பையனிடம் சொன்னார், ஆங்கிலம் படி, இங்கே நல்லா இருக்கலாம், அல்லது சமஸ்கிருதம் படி, அங்கே நல்லா இருக்கலாம் என்று ஆகாயத்தை சுட்டிக்காட்டினார். அதற்கு அந்த பையன், நான் தமிழ் படிக்கப் போகிறேன், தமிழ் படித்தால் இங்கேயும் நல்லா இருக்கலாம், அங்கேயும் நல்லா இருக்கலாம், எங்கேயும் நல்லா இருக்கலாம் என்று சொன்னான். அந்த பையன் வேறு யாரும் இல்லை நண்பர்களே, அவர்தான் தமிழ் தாத்தா உவே சுவாமிநாத ஐயர் அவர்கள். ஆக தமிழ் மொழி இம்மைக்கும் மறுமைக்கும் உகந்த மொழி. அக வாழ்க்கைக்கும் புற வாழ்க்கைக்கும் ஆன்மீக வாழ்க்கைக்கும் பொருத்தமான மொழி. அத்துடன் இன்றைய நம் விஞ்ஞான வாழ்வியலுக்கும் வழிகாட்டுகின்ற மொழி தமிழ் மொழி. உலகில் உள்ள ஆராய்ச்சியாளர்கள் ஒப்புக்கொண்ட 6 செம்மொழிகளிலே தமிழ் மொழி மட்டும்தான் இன்றும் நடைமுறையிலே இயங்கி வருகிறது. அது வலிமையோடும் பொலிவோடும் பேச்சு வழக்கிலும் எழுத்து வழக்கிலும் இளமையோடு இருந்து வருகிறது. ஒரு நாட்டில் நீதி வழுவா நெறிமுறை நின்று நிலவுவதற்கு அந்த நாட்டின் நீதி வழங்கும் நடைமுறை உரிய வகையில் அமைதல் வேண்டும். இதற்கு அந்த நாட்டு நீதிமன்றங்கள் அம்மக்கள் மொழியில் நடைபெறுதல் வேண்டும். அப்பொழுதுதான் அந்த நீதிமன்றங்களில் வெளிப்படைத்தன்மை புறப்படுகின்ற சூழல் உருவாகும். இவ்வகையில் இந்திய விடுதலைக்கு முன்னர் தமிழ்நாட்டு நீதிமன்றங்கள் தமிழ் மொழியில் இயங்குவதற்கான வாய்ப்பு அமையவில்லை. 1947 ஆண்டு ஆகஸ்ட் மாதத்திலே விடுதலை பெற்ற இந்தியா 1950 ஜனவரியிலே தன்னை குடியரசு நாடாக அறிவித்துக் கொண்டது. அவ்வாறு அறிவித்துக் கொள்வதற்கு அமைந்த ஆவணமே இந்திய அரசியலமைப்பு சட்டமாகும். இந்திய அரசியலமைப்பு சட்டத்திலே அந்தந்த மாநில மக்களின் மொழிகளை அந்தந்த மாநில அரசு அதன் ஆட்சி மொழியாக அறிவித்துக் கொள்ள வழிவகை செய்யப்பட்டிருந்தது. இந்த வகைமுறையை பயன்படுத்தி அப்போதைய சென்னை மாநில அரசு 1957 தமிழ்நாடு ஆட்சி மொழி சட்டத்தை வெளியிட்டது. அரசின் 3 பிரிவுகளான சட்டமன்றம், நிர்வாகம், நீதிமன்றம் ஆகிய 3லும் தமிழ் தங்கு தடையின்றி பயன்பாட்டு மொழியாக பயன்படுத்தப்பட வேண்டும். தமிழக அரசு நிர்வாகத்துறையிலே தமிழை ஆட்சி மொழியாக்கும் முயற்சியிலே நிர்வாக சொல் அகராதியை வெளியிட்டது. இதனைத் தொடர்ந்து நீதித்துறையிலும் தமிழே ஆட்சி மொழி என்பதை உறுதிப்படுத்துவதற்கு வேண்டிய ஏற்பாடுகளை செய்ய வேண்டிய தேவை எழுந்தது. தமிழ்நாட்டு நீதிமன்றங்களில் தமிழை வழக்காடு மொழியாகவும் தீர்ப்பு மொழியாகவும் பயன்பாட்டிற்கு கொண்டு வருவதற்கு அடிப்படை தேவையாக இருப்பவை தமிழில் சட்டக்கலை சொற்கள். எனவே சட்டக்கலை சொற்களை உருவாக்கிட 1957 ஆண்டு தமிழ்நாடு அரசு சட்ட ஆட்சி மொழி அகராதி குழுவை அமைத்தது. இதனைத் தொடர்ந்து தமிழ்நாட்டில் இருக்கும் நீதிமன்றங்கள் வழக்கை பதிவு செய்வதற்கும் சாட்சிகளை விசாரிப்பதற்கும் வழக்குகளை நடத்தும் பொழுது பின்பற்ற வேண்டிய நடைமுறைகளை வகுத்து சொல்வதற்கும் தேவைப்படும் சட்டங்களையும் இன்னும் பிற பல சட்டங்களையும் மொழிபெயர்த்து தமிழில் வெளியிடப்பட்டது. தமிழக அரசு பல்வேறு காலகட்டங்களிலே ஆட்சி மொழி ஆணையங்களையும் அமைத்தது. தமிழில் சட்ட சொற்களஞ்சியம் லா லெக்சிகன் வெளியிடப்பட்டது. அனைத்து இந்திய மொழிகளிலே தமிழ் மொழியில்தான் முதலில் சட்ட அகராதி வெளியிடப்பட்டது. இதிலிருந்தே தமிழ் மொழியின் சிறப்பினை எவரும் அறிந்து கொள்ள முடியும். தற்போது 2019 ஜனவரியிலே மாண்புமிகு சட்ட அமைச்சர் அவர்கள் பரிந்துரையின் பேரிலே மாண்புமிகு தமிழக முதலமைச்சர் அவர்களால் மாநில சட்ட ஆட்சி மொழி ஆணையம் அமைக்கப்பட்டது. இந்த ஆணையத்திற்கு சென்னை உயர் நீதிமன்ற நீதியரசர் மாண்புமிகு பொன் கலையரசன் அவர்கள் தலைவராக நியமனம் செய்யப்பட்டு ஆணையம் தற்போது அவர் தலைமையிலே இயங்கி வருகிறது. இந்த ஆணையத்தின் முக்கிய நோக்கம் தமிழகத்தின் சாதாரண குடிமக்களுக்கும் அடிப்படையான சட்டங்கள், விதிகள், உரிமைகள் ஆகியவை அவரவர் தாய்மொழியிலே படித்து தெரிந்து புரிந்து கொள்ள வேண்டும் என்பதாகும். மக்களாட்சி நடைபெறும் ஒரு நாட்டில் நீதிமன்றங்கள் மக்கள் மொழியில் செயல்பட வேண்டும் என்பதே மக்களின் விருப்பமும் வேண்டுகோளும் ஆகும். மக்களின் உணர்வுகளுக்கு மதிப்பளிக்கும் வகையில் தமிழக அரசு அமைத்திருக்கும் இந்த மாநில சட்ட ஆட்சி மொழி ஆணையம் தமிழில் சட்டங்களை மொழிபெயர்த்து வெளியிடுகிறது. தமிழ்நாட்டில் உள்ள கீழமை நீதிமன்றங்களில் எல்லாம் தமிழ் வழக்காடு மொழியாக செயல்பட வேண்டும். சட்ட மொழியாக நீதிமன்றங்களில் வழக்காடு மொழியாக தமிழ் இருக்க வேண்டும் என்பது என்னை போன்ற பல்லாயிரக்கணக்கான தமிழர்களின் விருப்பமாக உள்ளது. இதன் தொடர்பாக தொடரப்பட்ட வழக்குகளை பற்றியும் தமிழ்நாடு ஆட்சி மொழி சட்டத்தில் ஏற்படுத்தப்பட்ட சட்ட திருத்தங்களையும் நான் சொல்ல கடமைப்பட்டிருக்கின்றேன். சுமார் 40 ஆண்டுகளுக்கு முன்பாக ராமாயி எது முனியாண்டி கோனார் என்ற வழக்கிலே தமிழில் வெளியிடப்பட்ட தீர்ப்பானை ரத்து செய்ய உயர் நீதிமன்றத்திலே வழக்கு தாக்கல் செய்யப்பட்டு சென்னை உயர் நீதிமன்றம் தமிழில் கீழமை நீதிமன்றம் தீர்ப்பானை வெளியிட்டதை ரத்து செய்து உத்தரவு பிறப்பித்தது என்பதை நான் வேதனையோடு இங்கே குறிப்பிடுகின்றேன். 1976ஆம் ஆண்டிலே தமிழ்நாடு ஆட்சி மொழி சட்டத்தில் சில புதிய பிரிவுகள் சேர்க்கப்பட்டு சட்ட திருத்தம் செய்யப்பட்டது. அதன்படி கீழமை நீதிமன்றங்களில் தமிழ் வழக்காடு மொழியாகவும் தீர்ப்புகள் தீர்ப்பாணைகள் தமிழில் வெளியிட வேண்டும் என்பதும் கட்டாயமாக்கப்பட்டது. இதனை எதிர்த்து திரு ரங்கா என்பவரால் தொடரப்பட்ட வழக்கு சென்னை உயர் நீதிமன்றத்திலே 3 நீதியரசர்கள் கொண்ட முழு அமர்வு விசாரணை செய்து ஏறத்தாழ 10 ஆண்டுகளுக்கு பிறகு 1994 தமிழ்நாடு ஆட்சி மொழி சட்டத்தில் ஏற்படுத்தப்பட்ட சட்ட திருத்தங்கள் செல்லும் என்று தீர்ப்பளித்தது. இதற்கிடையிலே சென்னை உயர் நீதிமன்ற தலைமை பதிவாளர் அவர்கள் 5/1/1994 வெளியிட்ட ஒரு அலுவல் சுற்றறிக்கையின்படி கீழமை நீதிமன்றங்கள் ஆங்கிலத்தில் நீதிமன்ற தீர்ப்புகளையும் தீர்ப்பு ஆணையங்களையும் வெளியிட அனுமதி அளிக்கப்பட்டது. இந்த சுற்றறிக்கையை எதிர்த்து அதனை திரும்ப பெற வேண்டி உத்தரவு பிறப்பிக்க மதுரை உயர் நீதிமன்றத்திலே சோலை சுப்பிரமணியன் என்பவர் ஒரு வழக்கு தாக்கல் செய்தார். காலம் மாறியது. அந்த தமிழில் தீர்ப்பானை வெளியிட்டதை ரத்து செய்ய உயர் நீதிமன்றத்திலே வழக்கு போடப்பட்டது. ஆனால் 1994 அதே உயர் நீதிமன்றத்திலே ஆங்கிலத்திலே தீர்ப்பும் தீர்ப்பானையும் கீழமை நீதிமன்றங்களில் வெளியிட அனுமதி அளித்ததற்கு எதிராக வழக்கு தாக்கல் செய்யப்பட்டது. இந்த வழக்கினை மாண்புமிகு நீதியரசர்கள் ராமசுப்பிரமணியம் அவர்கள் மற்றும் மாண்புமிகு நீதியரசர் வேலுமணி அவர்கள் அடங்கிய அமர்வு விசாரணை செய்தது. கீழமை நீதிமன்றங்களில் வழக்காடு மொழியாக தமிழ் இருத்தல் வேண்டும் என்பதும் தீர்ப்புகள் தீர்ப்பாணைகள் அனைத்தும் தமிழில் பகரப்பட வேண்டும் என்றும் தமிழ்நாடு ஆட்சி மொழி சட்டத்திலே சேர்க்கப்பட்ட சட்ட திருத்தத்தை கருத்திலே கொண்டு தமிழ்நாடு ஆட்சி மொழி சட்டத்தின் பிரிவுகளை மதுரை உயர் நீதிமன்ற அமர்வு விரிவாக ஆராய்ந்து உயர் நீதிமன்ற பதிவாளர் வெளியிட்ட சுற்றறிக்கை சட்டத்திற்கு முரணாக உள்ளது என்று தள்ளுபடி செய்து உத்தரவு பகர்ந்தது. அதனை எதிர்த்து உச்ச நீதிமன்றத்திலே வழக்கு தாக்கல் செய்யப்பட்டு பேர் இடியாக உயர் நீதிமன்ற உத்தரவுக்கு நடைபெறப்பட்டுள்ளது. எனவே நண்பர்களே, தற்பொழுது தமிழகத்தில் கீழமை நீதிமன்றங்களில் தமிழில் வாதாடுவதும் தமிழில் தீர்ப்புகள் வழங்குவதும் நடைமுறையில் உள்ளது என்றாலும் கூட கீழமை நீதிமன்ற நீதிபதிகள் சென்னை உயர் நீதிமன்றத்திலே சிறப்பு அனுமதி பெற்று ஆங்கிலத்திலே வழங்கலாம் என்ற நிலை உள்ளது. இந்த நிலை மாற வேண்டும். கீழமை நீதிமன்றங்கள் தீர்ப்பாயங்கள் மற்றும் வருவாய்த்துறை ஆணையங்கள் அனைத்திலுமே நீதிமன்றங்கள் அனைத்திலுமே தமிழ் மட்டுமே வழக்காடு மொழியாகவும் தீர்ப்பு மொழியாகவும் இருத்தல் வேண்டும். காலப்போக்கில் உயர் நீதிமன்றத்திலும் தமிழ் வழக்காடு மொழியாக இருத்தல் வேண்டும். இதற்கு அனைத்து சட்டங்களும் தமிழாக்கம் செய்யப்பட வேண்டும். தமிழில் சட்ட ஆய்வு அறிக்கைகள் சட்ட பத்திரிகைகள் பெருமளவில் வர வேண்டும். சுமார் 4 நூற்றாண்டுகளுக்கு மேலாக சட்டக்கதிர் என்ற சட்ட பத்திரிகையை ஆய்வு நண்பர் டாக்டர் சம்பத் அவர்கள் எவ்வித பிரதிபலனும் எதிர்பார்க்காமல் லாப நோக்கத்தை கணக்கில் கொள்ளாமல் வெளியிட்டு வருவதை நான் இங்கே பெருமையோடு பதிவு செய்கிறேன். தமிழில் வெளிவருகின்ற சட்ட பத்திரிகைகளுக்குரிய மதிப்பினை நீதிமன்றங்கள் வழங்க வேண்டும். பேராசிரியர் முத்துவேல் அவர்கள் சென்னை பல்கலைக்கழகத்திலே முதன்முறையாக சட்ட தமிழ் என்கின்ற பொருளிலே ஆய்வுகள் செய்து முனைவர் பட்டம் பெற்றுள்ளார் என்பதையும் நான் பெருமையோடு இங்கே பதிவு செய்ய விரும்புகிறேன். சட்டங்களையும் விதிகளையும் குறித்து தமிழில் மேலும் பல ஆய்வு கட்டுரைகள், கருத்தரங்குகள், சட்ட மொழிபெயர்ப்புகள் உடனுக்குடன் வெளியிடப்பட வேண்டும். பேரறிஞர் அண்ணா அவர்கள் தமிழக முதலமைச்சரான பின்னாலே ஒரு நாள் சட்டக்கல்லூரி மாணவர்கள் அவரை சந்தித்தார்கள். பேரறிஞர் அண்ணா அவர்கள் அவரிடம் சட்டப்படிப்பை தமிழில் படித்தால் எப்படி இருக்கும் என்று கேட்டார்கள். அதற்கு அனைத்து மாணவர்களும் தமிழால் முடியும் என்று சொன்னோம். பேரறிஞர் அண்ணா அவர்கள் சொன்னார்கள், தமிழால் முடியும் என்பது எனக்கும் தெரியும், உங்களுக்கும் தெரியும். ஆனால் தமிழால் சட்டம் படித்து வாழ்க்கையில் வெற்றி பெற முடியும் என்பதை நீங்கள் பதில் சொல்லி இருந்தால் நான் மெத்த மகிழ்ச்சி அடைந்திருப்பேன் என்று சொன்னார்கள். பேரறிஞர் அண்ணாவின் கருத்தை இன்றைய இளைஞர்கள் எல்லாம் உள்வாங்கிக் கொள்ள வேண்டும். எனவே தமிழ் வழக்காடு மொழியாக நீதிமன்றங்களின் பயன்பாட்டில் இருந்தால் நாங்கள் வாழ்க்கையில் வெற்றி பெறுவோம், வெற்றி பெற முடியும் என்று சட்டம் பயில்கின்ற மாணவர்களும் வழக்கறிஞர்களும் எண்ண வேண்டும். அந்த எண்ணம் செயல்படுதல் வேண்டும். இதனை அனைத்து தமிழர்களும் இதயத்திலே பதிவு செய்து கொள்ள வேண்டும். அதனால் தான் ஆரம்பத்திலே சொன்னேன், நான் உங்கள் இதயத்தோடு பேச விரும்புகிறேன். சட்டங்களை தமிழில் வெளியிடுவது என்பது தமிழின் வளர்ச்சி மட்டுமல்ல, அது சட்டத்தின் மாட்சி, மக்களாட்சியின் மாண்பு. இவற்றை கருத்திலே கொண்டு நாம் நமது பணிகளை இடையறாமல் நிறைவேற்றுவோம் என்று கூறி விடைபெறுவதற்கு முன்பாக நான் ஒன்றை குறிப்பிட விரும்புகிறேன். இன்று இல்லாவிட்டாலும் என்றாவது ஒரு நாள் தமிழ்நாட்டு நீதிமன்றங்களே வழக்காடு மொழியாக இருக்கும் என்பதிலே எனக்கு எவ்விதமான ஐயமும் இல்லை. கடைசியாக மாண்புமிகு உச்ச நீதிமன்ற நீதியரசர் அவர்கள் இங்கே பேசும்போது சொன்னார்கள், தீர்ப்புகள் தமிழில் வெளிவருவதனுடைய அவசியத்தை தெளிவாக எடுத்து சொன்னார்கள். அவர்களுக்கு நான் நன்றி கூறுகிறேன். அதே போலவே மாண்புமிகு நீதியரசர் ராஜா அவர்கள் அரசு மற்றும் தனியார் சட்டக்கல்லூரியிலே படித்து வெளிவரும் வழக்கறிஞர்கள் சந்திக்க இருக்கும் இடர் பற்றி தெளிவாக சொன்னார்கள். தமிழக அரசும் உயர் நீதிமன்றமும் பார் கவுன்சிலும் இணைந்து இதற்கான தீர்வு காண வேண்டும் என்ற வேண்டுகோளையும் இந்த கூட்டத்தின் வாயிலாக எடுத்து வைத்து நன்றி கூறி விடைபெறுகிறேன். நன்றி, வணக்கம்.
நன்றி. திரு சங்கரன் அவர்கள் ஒரு தெளிவான விளக்கமான ஒரு உரையை நிகழ்த்தினார்கள். அவர்கள் தமிழில் இந்த சட்டக்கதிர் சார்பில் நடக்கிற இந்த மாநாட்டில் தமிழில் உரையாற்றி இருப்பது எங்களுக்கெல்லாம் மகிழ்ச்சி அளிக்கிறது. தமிழ் குறித்து தமிழை எப்படி சட்டமன்ற நீதிமன்ற மொழியாக கொண்டு வர வேண்டும் என்பதை பற்றியும் சட்ட இதழ்கள் கொண்டு வர வேண்டும் என்பதை பற்றியும் விளக்கமாக எடுத்துக் கூறினார்கள். அவருக்கு எங்களுடைய அன்பு கலந்த நன்றியினை தெரிவித்துக் கொள்கிறோம். நெக்ஸ்ட் ஐ எம் ரிக்வெஸ்டிங் Mr. R. Vidudali, Senior Advocate and also former Advocate General of Tamil Nadu and sitting member of the Tamil Nadu Bar Council, will deliver his speech on federalism and concurrent list. Mr. Vidudali.
Yeah, dear brothers and sisters, and I thank Dr. Sampath for giving me this wonderful opportunity. And before I start my lecture, I thank Madam Justice Indira Banerjee, Justice T. Raja, Justice Gopal Sriram, Justice Vimala, Justice Durai Karunakaran, Mr. Sankaran for the enlightened intellectual inputs given by them in this conference. Now I am here to give my thoughts on federalism and concurrent list. Federalism, as we all know, is a concept which emanates from a federal government. There are two types of government in the world. One is the federal government and the other one is a unitary form of government. We know that in a federal government, political powers or the powers of governance are divided between the national government and the regional governments or provincial governments. And in a unitary form of government, there is only one government which makes all the laws for the entire country. There are about 200 countries in the world, 195 plus countries in the world, of which 25 countries have got federal form of government. Even though they are less in number, 40% of the population comes under the governance of these federal countries. As of now, the population of the world is 783 crores. of which nearly 300 crores people are governed by a federal form of government. The famous federal governments are, the countries with federal form of governments are USA, United States of America, Australia, Canada, Malaysia, and of course, India. India, while describing the form of government in India, Harold Lasky, an eminent constitutional jurist, said, India has a constitution, India has a federal constitution with a pronounced unitary bias. Therefore, Indian federalism is a quasi-federalism. Before we come to India, let us have a look at the American, Australian, Canadian, and Malaysian constitution at a glance. In America, there are three types of powers, that is, subjects with regard to which the federal government can make laws. There are subjects with regard to which the state government can make laws. And there is a list called the general powers, where both the federal government and the state government can make the laws. But there, I tell you, the residuary powers are vested with the state government. And the state has got greater autonomy, greater political power, and the federalism has worked well, basically because the sentiments of the states are respected. As we all know, America was originally 13 colonies, later became 50 states, united into an United States of America, and this federal system of government is working well for more than 200 years. The American Constitution was given in the year 1789, and more than 200 years it has worked well. But the residuary powers are with the state governments. Now let us go to Australia. Australia was originally consisted of 6 British colonies: Queensland, New South Wales, Southern Australia, Western Australia, Tasmania, and Victoria. All these 6 British colonies came together and formed the Federation of Australia. There it is called the Commonwealth government. The federal government is called the Commonwealth government, and the states have got their own powers. And the interesting feature of the Australian Constitution is the Constitution cannot be amended except after a referendum by the people, where the majority of the people approve, and thereafter 4 out of the 6 states, which I told you, approve the amendment of the Constitution. It is a very, very truly federal form of government. And I tell you, there is no concurrent list in Australia. A federal government which has no concurrent list. Either the powers are vested with the Commonwealth government, or the federal powers are vested with the states. That is the Australian Constitution. Let us come to Canadian Constitution. Canadian Constitution and Malaysian Constitution are very much like our Constitution. You've got a federal list or a union list. You've got a concurrent list, and you've got the state list, where the union government can make laws, and then the state, provincial governments can make laws, and the concurrent list, where both the state governments and the central government can make laws. Take the Canadian example. Canada has a concurrent list, but you'd be surprised to know there are only 3 entries in the concurrent list. One is immigration, the other one is agriculture, and the third one is pension, old age pension. These are the 3 lists in the Canadian Constitution. So that federalism has worked well in Canada, which Constitution of Canada is more than 100 years old. We know that the Constitution Act of Canada is 1867, and the Constitution Act of Australia is 1900. Why I am citing all this? India, let us now come to, and Malaysia is very much like India because they have got the federal list, they have got the union list, state list, and concurrent list. And in Malaysia also, the residuary powers are vested with the states only. In Canada, the residuary powers are vested with the federal government, as in India. This is the major political federal scenario that we have got. Take India. 300 years ago or 400 years ago, India, as we know of now, consisted of about 565 different distinct tiny countries, petty principalities. It was not a single country. And after the discovery of sea route by Vasco da Gama in the year 1489, then the Dutch came in first via the sea route, followed by the French, and thereafter by the British. They started colonizing India, and ultimately we all know that Britishers consolidated the British India, and all these petty principalities started disappearing. And that is the reason why we have got multi-ethnic, multicultural, multi-language, multi-custom. We have got unity and diversity. While so, what happened was, in 1919, Government of India Act had a provincial list and a union list. 1935 Government of India Act, which is the forerunner of the Constitution of India, it created a concurrent list. This was taken over. The British legacy of the Government of India Act of 1935 was incorporated in the Indian Constitution. Now, let us come to the Constitution of India. The Constitution of India, interstate relations or center-state relations are dealt with in Part 21 of the Constitution of India between Articles 245 and 255. And the concurrent list is talked about in 3 articles, Articles 246, 248, and 254. What does it say? Article 246 says that the list 1, which is the union list, contains the list of subjects or legislative fields in which the central government can make laws. And list 2, the state list, contains items in which the state government can make laws. And concurrent list is a list where both the state government and the central government can make laws. See, the union list consists of 97 subjects and state list consists of 66 subjects and the concurrent list consists of 47 subjects. But after the 42nd Amendment, where 5 entities were taken away from the state list and added to the concurrent list, say for example, education, forest, protection of animals, birds, and then of course you have got the ecology or I forget the other 3 entities. They were taken over, wildlife, if I remember right. They were taken over from the state list and given to the concurrent list. So the question before me, the analysis which I have done is, if the federal form of government is a part of the basic structure of the Constitution of India, if that is the basic structure of the Constitution of India, it cannot be amended because it forms the basic structure. And if basic structure of the Constitution of India cannot be amended, then the 42nd Amendment, which has migrated or which has transferred 5 entities from the state list to the center list or to the concurrent list, whether it is justified or not, it is a matter which calls for national debate. That apart. Now let us see whether there are debates, there are intellectuals who tell you that in India, originally when the Constitution was given, there were concerns about our solidarity and unity. Those concerns are addressed as of now, and India is now a country which has solid unity. We have got unity and diversity. Therefore, the oneness of India is not in doubt. Now the question is whether more powers ought to be given to the states or not. And there are 3 commissions which have gone into the matter. First of all, there was a Sattakadir commission which entered in the matter regarding center-state relationship. And thereafter, the Rajmanar committee, even before that, that went into the matter. And lastly, the Punchi committee, they went into the question of center-state relations. And they ultimately concluded this state requires more powers. Now that residuary powers are with the central government, 97 entries are with the central government, and then 47 concurrent lists are also with the central government. And state list has got only 66 items. And after the migration of 5 items, we have got only 61 items with regard to the state list. Therefore, the national debate that is now on is whether our constitution requires a concurrent list at all. Why not we distribute the items in the concurrent list one way or the other? Either give it to the union government or give it to the state government. Don't keep a concurrent list because it creates more confusion than it seeks to solve. That is one aspect of the matter. That is because Australian constitution does not have a concurrent list. Therefore, follow the Australian model. That is one aspect of the matter. But secondly, why not you follow the Canadian model? No, if you want, and if you see that a concurrent list is a must in every federation, because Canada, it has worked well in Canada for more than 100 years. Therefore, we should have a concurrent list. Then you follow the Canadian model. You should have a minimum of 3 or 4 items, not more than 5 items in the concurrent list. Therefore, the idea that I would put to the audience here is my own analysis would lead to the conclusion, either you remove the concurrent list and distribute the items in the concurrent list either to the state or to the union. Kindly think about that. And then of course, or have the minimum entries in the concurrent list so that there will be stability of governance People will know what is what. And again, I tell you, states have been divided on linguistic lines. Language is akin to education. Therefore, education must be only with the center, or only with the state governments, because you have bifurcated or trifurcated or constituted a state only on language basis, linguistic basis. Language and education go together. Therefore, bring back the education to the state list. Don't keep it in the concurrent list. Education must come back. Even the 44th Amendment has failed to do so, and it has to do that. That is one aspect of the matter. Why I am saying this, now that the India is a consolidated sovereign nation, if it has to grow in the right direction like the America or Australia or Canada, you have to necessarily give more powers to the center. Otherwise, what happens? History tells us. In 1950, we had a superpower. We had a very big power called USSR. Where is it today? It is not there today. Why? It is now 288 countries. Union of Soviet Socialist Republics, which was a superpower threatening the very powerful existence of USA, is no longer there. It has dissipated into 28 different countries. So the history tells us, look here, you give enough powers to the state governments to grow in a federation. If enough powers are not granted, what happens? We do not know. I'm not suggesting anything, but we have to learn lessons from history. Because when eminent jurist said, look here, you have to learn lessons from history. If you don't learn the lessons, then history will teach you the lesson. And an Uruguayan journalist, a famous quote is, look here, history never tells goodbye. It says, see you again. Therefore, history repeats itself. So therefore, I would earnestly request all the constitutional pundits to think about what happens to the concurrent list, whether we should totally remove the concurrent list and distribute the items in the concurrent list to either the state list or the union list, or keep a minimum entry in the concurrent list, or then like the Canadian model, or should we not have more powers? See, centralization of powers, as some feels is happening today, does not augur well for the political governance of the country. If India has to become a superpower, we have to necessarily think twice about the concurrent powers in our constitution, and requires some deep thought and deliberation and calls for a national debate. Lord, this is my idea of the matter. Therefore, I thank Dr. Sampath and the audience for the opportunity that been given to me, and the patient way in which you have listened. They kindly consider whether a true federation should have equal balance of powers or centralization of India is not a unitary form of government. It's a federal country. Therefore, let us keep it federal. Let us respect the unity in diversity. Let us respect the multi-ethnic, multicultural, multi-custom, multilingual nature of India, and let us all grow together to become the most powerful nation in the world by disseminating the powers to the federating units. Thank you very much for the opportunity. I thank you.
Thank you, Mr. Vidudalai. You gave a wonderful speech for today's perspective. Today, India facing a lot of issues, a lot of regional political parties, a lot of regional parties ruling in different states, and everybody wants power. In this situation, how India should go further, the power should share. This subject is very, very, very important subject to put a separate conference. We are thinking to put separate conference also. First level, we put one person should give a speech on this. I am very much thankful to Mr. Vidudalai for a wonderful speech on this.
Thank you.
Now I am requesting Dr. M. Gandhi, Professor and Dean of VIT School of Law, VIT University, former Joint Secretary, Ministry of External Affairs, Government of India, New Delhi, will give a speech on international law making. Mr. Gandhi, my good friend.
Thank you very much, Dr. Sampath. And it has been a great evening to listen to that kind of erudite speakers and listen to the vibrance of law. The Sattakadir Global Conference on Law and Justice, and really want to make, I think you want to make, it is a global, that is why, you factored international law, a global law and global justice. And first, I thank all the speakers, including the judges of the Supreme Court, as well as the high courts and past and present, and the judges from overseas. Now, this is just, it is a vast area and it is a technical area also. I don't want to, in fact, mar the pleasantness of the evening by getting into the detail, but at the same time, I want to give enough information to know about what the international law making is. First of all, the international law, to find out where it is and how to find out itself is an issue. But the law making is another complicated issue. Let me try to just make it simple. Now, what is international law? The body of legal rules and norms and standards that apply between sovereign states and other entities that are legally recognized as international actors. So the subjects are increasing, objects are increasing. At one point of time, states were only the subjects of international law. Now, slowly we are adding, the international law adds not only the states, but international corporations, and it is trying to add international organizations and individuals also. And when we are talking about the international law, and we are talking the international hard law and soft law. The hard law is a law that is already binding. I mean to say that the treaty law or the customary international law that is going to be a hard law. As far as a soft law is concerned, we call it lege ferenda. It would emerge as a future hard law. But at the same time, when you want to just adopt it as a hard law, you can do it right away. That kind of law, we say that it is a soft law. So the biggest problem in the lawmaking in international law is there is non-existence of centralized governance structure. We don't have world government, we don't have world parliament, and we don't have world executive. So with the result, what happens is, we don't have a centralized legislature or judiciary, and the judiciary, the ICJ and others, they are consent-based. If the sovereign states are not giving consent, and they cannot entertain the cases. So the lawmaking and implementation is completely controlled by two important principles. One is sovereignty, the other one is national interest. And a cementing factor that unites these two things, the sovereignty and national interest, is cooperation, international cooperation. When the international cooperation fails, no law is made. So what is important is between the sovereignty and the national interest, when there is an international, the cooperation, there is some flexibility that is shown so that the law is made. No, but at the same time, there is a viewpoint generally. I think even in the old timers, they used to think about that international law is not law at all. It's an old story. Nobody, regard that today. And that kind of an argument is not acceptable because most of your legislations, the national legislation of every country, as well as the judicial decisions, and most of the time, it is influenced by international law. So, as such international law, I would quote Louis Young here, almost all nations observe almost all principles of international law and almost all of their obligation almost all of the time. So repeat it, you can say that, almost all, almost all, almost all, almost all, 4 times. So the point is that exceptionally, some countries may not observe international law. But naturally, by default, every country would accept and observe international law. Those who are not observing international law also, they would always argue they are within the presence of international law. They never say that they won't observe international law. So that is the merit of it there. Then when you say that it is a lawmaking, what kind of lawmaking? For that, what are all we call as international law? For that, only one referral point is there. It is the Article 38 of the Statute of International Court of Justice. But that statute, that reference is only for the purpose of settlement of dispute, that's all. Beyond that, they may have different definitions of international law. For settlement of dispute, they say that maybe, this convention general or particular, that means it is a bilateral, trilateral, quadrilateral, or multilateral, plurilateral, or universal treaty. if you interpret that way, in whichever form that binds states and the law is created. It's like that. And secondly, it is a customary law. And the customary law is completely, we know that the customary law, it will take long usage at one point of time. It is not true. And today, customary laws can be made even within 10 years. Space law is made within 10 years through customary law. And even today, there's all the terrorism conventions, which are all almost customary today. And these are all made within just 20 years time. And even 1982 to now, almost most of the customary law has been made in maritime zones. So the customary law is made by a social interaction process. That means it is not exclusively states are involved in that. Even the other subjects of international law also involved in it, in the creation of a custom. While treaty law is completely state-centric, but the customary international law is not like that. The participation of the people also involved in that. That is what, the famous right to passage case, the Portuguese versus India, the right to passage was created by the people in Goa over the territory in India. So it was created the same way, so it's a social interaction process that gives rise to the creation of a custom, that is law. Then secondly, another important thing is that whether this way or that way, either treaty or a custom, the centralized way is the consent is the basis of a creation of international law. Now the consent has been little, flexible today. It is not a consent of every state that is required. So they call this, it is not consent, it is consensus that is the basis of international law. When it is a consensus that is going to be basis of international law, and in which kind of a setting the international law is created, you have to see. Mostly international law is created in institutional settings. When in institutional settings it is created, almost a parliamentary type of procedure is followed. It is not just like that they gather and do that. No, it's not possible. They'll have a committee system, they have a working group system, all kinds of things are there as far as within the institution. If it is outside institution, they may go for a kind of ad hoc conferences, and all the ad hoc conferences they will adopt. Even the interest groups themselves, group of states themselves will trigger. And let us see a little after some time that one. Now the states are the center in lawmaking, as I told you, but there is another source of international law, that is a general principles of law recognized by civilized nations. Here, it is the judiciary is picking up the general principles from the municipal legal system. So it is, the municipal legal system, from that they pick up the principle like res judicata, equity, all kinds of things are picked up from the, the civilized system of law, where, in the municipal law, and they will pick up, they can use it when there is no definite law of custom and treaty that is existed in the corpus of international law. We call this as non-leke situation. There is no law situation. When there is a non-leke situation, they can't say that there is no law, therefore, we won't apply. And they are allowed to have whichever way to come to settle the dispute. Therefore, they pick up the general principles of law recognized by civilized nations. And wherein you can find that opinions of the publicists as well as even the judicial decision. Judicial decisions are not binding. Earlier judicial decision of the ICJ is not binding on subsequent courts. Judicial decisions are just opinions. It is something like you give an opinion, I give an opinion. Judicial decision is also an opinion, because that opinion will have a great weight because more number of heads are used. That's all. So the institutional law making. Let us see the UN practice, because it is a known model through which the law is made. Now, Article 13 of the UN Charter, it says that the General Assembly shall initiate studies and make recommendations for the purpose of promoting international cooperation in the political field and encouraging the progressive development of international law and its codification. So to make a law in the UN General Assembly, and you have to inscribe agenda. First, it goes to the General Committee. General Committee will agree. If General Committee agrees, because there is a lot of difficulty even putting up a particular framework of law. And the General Committee agrees, then agenda is completed. When the agenda is floated, then the agenda will follow. When the agenda follow, there are about 6 committees, and according to the nature of the law they want to do it, that committee it will go. But 6th committee is generally, it is a legal committee. And that means, only the international lawyers are there. All the 193 countries they have in the 6th committee, one representative is sitting there. So it is something like a classroom, everyday basis, the business will go on that. So what happens is that now the whole thing will go to the 6th committee. There are 4 ways, you can make this kind of a thing in the UN. One is ILC, the International Law Commission, which is like our law commission, and they will come with a recommendation to the 6th committee, the legal committee. That is one way. And that recommendation will be adopted. After that, there is a conference on plenipotentiaries and they can adopt this. That is one way of doing it. The other way of doing it is that the 6th committee itself come with a proposal to make a law, and it will constitute a working group there. That working group run for 3 years, 4 years, something like that. All anti-terrorism conventions are coming through the working group, via working group only. And they'll finally adopt it. And once adopted, it will go to the UN General Assembly, and General Assembly adopt that convention. And third thing is that the ILC draft, it will go to the 6th committee, but 6th committee will shift it to further pruning by some other external plenipotentiary meeting. The conference will be held not within the UN, it is outside the UN with the support of the UN. Because all the International Criminal Court, that is the Rome Statute, and that was created in that pattern. Because it will come from the ILC, the draft. The draft will be analyzed by the 6th committee. 6th committee approves it. It will go back to the plenipotentiary meeting, and the plenipotentiary meeting will be held elsewhere, not within the UN. Then finally, they will adopt it. So all this process, there is a settled procedure. It is like the Erskine-May's parliamentary procedure, like that. There is a procedure for that. That procedure is called that UN General Assembly Rules of Procedure. And if you go to the UN website, you can just take it to what the internal procedures, and where all kinds of things, why the voting should happen, how, and if it is unanimous, how it will be. All these things are given there. Then similar way, almost a similar way, all allied agencies, they make law. Allied agencies make law. Say, for example, Outer Space Legal Subcommittee. This is in Vienna. And the lawmaking in UNESCO. This is in Paris. Lawmaking in ICAO. This is in Montreal. Lawmaking in IMO. This is in London. Lawmaking in UNEP. This is in Nairobi. So what happens is these are all UN affiliates, but at the same time, in a sectoral way, they make law. Finally, it will come to General Assembly. So the negotiations and the final adoption would happen someplace. When the draft comes, it will come only to the General Assembly, and General Assembly will always adopt it. There also, it is only the UN rules of procedure should be followed. Then non-institutional lawmaking. This I was telling you that it is a bilateral, trilateral, quadrilateral, plurilateral. Anyway, say for example, the EU treaty that we call that Maastricht Treaty, and that treaty was made by the EU members in a particular place. Similar way, along Africa, they can make international law, the regional international law by themselves. They can make a law, and they keep doing it. And the trade law they can make, say, like NAFTA, North Atlantic, this North American trade. For that purpose, the NAFTA meeting, they have a NAFTA like WTO, they have a NAFTA, separate NAFTA they have. So they can always make from outside also. And another outside UN, that would happen, say if the interest party in a particular sectoral area, they want to make law, it will happen by the agency which promotes that. So now, we know that there is a landmine ban treaty. And the landmine ban treaty was in fact developed with the help of ICRC. And it was completely pushed by Europe. And it has completely negotiated outside UN, but at the same time in multilateral format. And they have adopted, it becomes international law. Then the convention, and that is prohibiting cluster munitions. This was also promoted by ICRC, and now it has come now. So what important thing is that, so wherever the law is made, there are two things here we must understand, that international law and international obligation, these two things are completely different. When an advocacy group says that it is international law, it is true, it is international law. But as a party or a non-party, I am bound by that or not, that is another question. So this question will not come at all in municipal law. Because where sovereignty is there, you decide. So in negotiation, you are participating in the negotiation, you decide. Participating in negotiation, you sign the treaty or not, you decide as a state. After signing it, you ratify it not, you decide. After ratifying it, whether it needs to be integrated in the municipal system of law to implement, you decide. So there are so many places where without the consent of the state, nothing moves. So the entire international lawmaking is, by and large, it is state-centric today. And the latest development is that even the non-governmental organizations also participating in the process in certain cases when a pressure is there. This is a second important area, especially the socio-economic and cultural issues, where now, as I, for example, the Convention on Child and Women and that kind of a thing, normally the NGOs also play an important role, but they don't have equal role to play today. And perhaps, they will also play like that. And another important thing is the international conferences, they play a crucial role in standard setting, although it is that is a soft law formation, I told you. Like, there's a Rio Declaration, Stockholm Declaration, and all declarations are only the soft principles. And these principles can be adopted by states who are willing to adopt them. So these are all the things, the international lawmaking is concerned. It is an essential matter that needs to be looked into. Thank you very much for giving this opportunity. I thank all the listeners who are very patiently listening this complicated issue. Thank you.
Thank you, Dr. Gandhi. You've given a long, wonderful speech about international law, how the works for making a law in United Nations and other agencies, because I am part of international law activities and international relations. I always observe about these many things by traveling from all over the world, attending the conference. It is a wonderful speech you delivered. Thank you. I'm requesting now Ms. V. Nalini,
thank you,
advocate and former president of Women Lawyers Association, Madras High Court, about the role of women lawyers in judiciary. Nalini? Yes. Unmute பண்ணுங்க. Okay.
அனைவருக்கும் வணக்கம். Honorable Justice Madam Indra Banerjee, Judge Supreme Court of India, Honorable Justice Mr. T. Raja, Judge High Court Madras, and Honorable Justice Gopal Sriram, and Honorable Dr. Justice Vimala Madam, then Sir Dr. VRS Sambat Sir, Sattakadir Asrier, and many speakers, senior advocates. First of all, I would like to thank, and I have the special and great privilege on Sattakadir, because Sattakadir அப்படின்னு நம்ம எடுத்துக்கிட்டோம்னாலே உண்மையிலே தமிழ் சாருங்கெல்லாம் நிறைய பேர் சொல்லியிருக்காங்க இல்லைங்களா, ஒரு ஜட்ஜ்மெண்ட்டை வந்து தமிழ்ல நம்ம படிச்சு, அதாவது நம்மளோட ஓன் லாங்குவேஜ்ல நம்ம படிச்சு தெரிஞ்சுக்கிறதுங்கிறது அது முதல்ல புரிதல் வேணும் நமக்கு. ஸோ அந்த ஒரு ப்ளஷரை வந்து ஒரு சந்தோஷத்தையும் ஒரு இதையும் கொடுத்தது நம்மளுடைய சம்பத் சார் தான். ஸோ அவருக்கு முதல்ல என்னுடைய நன்றி, மனமார்ந்த நன்றியை நான் வந்து ரொம்ப தெரிவிச்சுக்கிறேன். அண்ட் மோர் ஓவர் ஐம் so proud to be the part of this global conference first of all. அண்ட் மோர் ஓவர் சட்டக்கதிரை பத்தி நம்ம சொல்லணும் அப்படின்னு நிறைய விஷயங்கள் இருக்கு, பட் டைம் கிடையாது. நிறைய 5:30லேருந்து நம்ம பேசிட்டு இருக்கோம், நம்ம கேட்டுட்டு இருக்கோம். ஸோ எல்லாத்துக்குமே ஒரு பொறுமைக்கும் ஒரு எல்லை உண்டு. ஆனால் நான் ரொம்ப பேச விரும்பல. ரோல் ஆஃப் விமன் லாயர்ஸ் இன் ஜுடிஷியரின்னு எடுத்துக்கிட்டோம்னு மை experience and as a president, former president, I have, and many of the former presidents also have given representation to the judiciary, both to the Supreme Court as well as High Courts, for more and more advocates to be appointed as women judges, that too especially from bar. அதுல என்ன ஒரு pathetic இது அப்படின்னு சொன்னீங்கன்னா, pathetic சொல்ல முடியாது. And we, at present scenario, I think we have only 8 women judges in our High Court, which is very less. And moreover, we say we have 1/3 reservation, everything, but as far as the total strength is concerned, as of now, we have not succeeded even 1/3. I have to say, it's only meagerly 8 or there, if I'm right. And according to the Supreme Court, if we take means there are only 2 women judges. Our Madam Indra Banerjee and Indra Malhotra Madam is there. So from actually Chief Justice of India அப்படின்னு நம்ம எடுத்தோம்னாலே ஒரு விமன் கூட இது வரைக்கும் இல்லை. அது எனக்கு ரொம்ப வருத்தத்தையும் தருது. There are many potential women lawyers are there, and I really appeal to the central government as well as the state government, and the global conference மூலமாகவும் நான் அந்த ஒரே ஒரு விஷயத்தை தான் நான் ரிப்பீட்டடா சொல்றேன். விமன் லாயர்ஸ் அப்படின்னு எடுத்துக்கிட்டாமலே நம்ம வாக்ஸ் ஆஃப் லைஃப்ல எவ்வளவு கஷ்டப்பட்டு நம்ம எல்லாம் வர்றோம். ஆஸ் லாயர்ஸ் நம்ம ஷைன் பண்றதுன்னு பாத்தீங்கன்னா, we are in சென்னை ஹைகோர்ட் வரைக்கும் பொறுத்த வரைக்கும் எடுத்தீங்கன்னா ரொம்ப அருமையா நிறைய பேர் பண்ணிக்கிட்டு இருக்காங்க. அந்த collegium has to consider them, and I really appeal to this government as well as the சட்டக்கதிர் இதன் மூலமாகவும் தெரிவிச்சுக்கிறேன் நான். அண்ட் சட்டக்கதிர் வந்து அவங்களோட பப்ளிகேஷன்ஸ் எல்லாமே எங்க அசோசியேஷனுக்கு அனுப்பிச்சிட்டு இருக்கிறாங்க. அண்ட் ஒவ்வொரு வருடமும் வந்து ஹானர் பண்றதும் வந்து ஒரு பெருமிதத்தை கொடுக்குது. ஸோ அதன் மூலமாகவும் நாங்க வந்து நல்லாவே நாங்க ஹலோ சாரி ஸோ விமன் ஜட்ஜஸ் பீங் அப்பாயிண்டட் அப்படின்னு நம்ம எடுத்தோம்னாலே கண்டிப்பா அதுல வந்து ரொம்ப கம்மியான விமன் லாயர்ஸ் தான் இருக்கிறாங்க. சர்வீஸ்ல இருந்து டெபியூட் பண்றாங்க, இப்ப வரப்போறாங்கன்னு சொல்றாங்க. பட் மை ஹம்பிள் சப்மிஷன் இஸ் தட் more women lawyers or potential women lawyers are there from bar. The government has to consider them, and they have to take initiative steps to appoint more and more women lawyers for the judiciary post. And one more thing, நம்ம விமன் அசோசியேஷன் அப்படின்னு நம்ம எடுத்துக்கிட்டோம், அட்வொகேட்ஸுக்குன்னு பார்த்தீங்கன்னா மோர் இன்ஃப்ராஸ்ட்ரக்சர்ஸ், நிறைய ஃபெசிலிட்டிஸ் ஆர் வாண்டட். இந்த சட்டக்கதிர் குளோபல் கான்ஃபரன்ஸ் மூலமா ஐ திங்க் சம்பத் சார் வில் டேக் டு த கவர்மெண்ட் ஆல்சோ. ஐ ஹோப் ஈவன் வி ஹவ் ரெப்ரசன்டட் that there be I mean நிறைய infrastructure facilities போனோம். நிறைய சென்ட்ரல் கவர்மெண்ட் has given us the library infrastructure கூட கொடுத்துருக்காங்க. அண்ட் மோர் ஓவர் செப்பரேட் சேம்பர்ஸ் வந்து விமனுக்கு தேவை, நிறைய ஃபெசிலிட்டிஸ் எல்லாம் தேவைப்படுது. அண்ட் விமன் லாயர்ஸ் வந்து நிறைய விஷயங்களை வந்து நல்லா பண்றாங்க. ஸோ திரும்ப சொல்லக்கூடிய ஒரே விஷயம் வந்து விமன் லாயர்ஸை வந்து கன்சிடர் பண்ணணும் ஜட்ஜஸ் போஸ்ட்டுக்கு. அண்ட் ஐ டேக் திஸ் ஆப்பர்ச்சுனிட்டி அண்ட் கங்க்ராச்சுலேட் மிஸ்டர் சம்பத் சார், அண்ட் ஐ விஷ் ஆல் சக்சஸ். Thank you so much. Vanakkam.
Thank you, Nalini. You are a wonderful speech about the problems of women lawyers, and you've given a lot of support to conduct this conference. You've taken a lot of initiative to fix Honorable Justice participate in this conference. Requesting Honorable Justice Raja is presiding the function to say a few words to conclude this session. After that, the vote of thanks. Requesting Justice Raja to say a few words.
Dr. Sampath, Leonard, distinguished speakers and participants. In fact, we have been hearing various learned speakers request and their preparations on various important legal issues. Although Dr. Sampath has been organizing this global conference on law and justice as 2 days conference. Amidst all his personal and official work, today, as a speaker, participant, and as a judge to preside over, I've seen that all the distinguished speakers have really taken so much of effort to enlighten the members of the legal fraternity. It goes without saying that the credit has to go to Dr. V.R. Sampath. I therefore renewing my request that this type of conferences should continue, with a request to the members of the bar to cooperate with Dr. Sampath to continue this type of legal learning. I request Dr. Sampath to take these steps to higher platforms. Every 6 months or 1 year, this type of conferences should be held so that the members of the bar, the institutions, the common men also will stand benefited. Thank you so much.
Thank you, Honorable Judge Sir. You've given a wonderful final note. I'm requesting all the speakers to send their speeches by email because we are trying to put as a booklet for all 3 days. Together. It will be useful for all the judicial institutions and the law colleges. Now I'm requesting Dr. Muthuvelu, member of the Tamil Language Commission, member of the Sattakadir Editorial Board.
Thank you, sir.
Yes.
Good evening, everyone who has been participating this called Global Conference on Law and Justice for the last 3 hours. As we are running short of time, I would like to thank, first of all, I would like to thank Justice T. Raja, Judge High Court of Madras, who has come forward with many suggestions. He stressed the importance of giving training to lecturers, assistant professors and government and private law colleges in order to raise their standards. He analyzed various aspects of legal education, the role of Bar Council in reshaping the curriculum and also to providing training to law college faculty members. Sir, we are very grateful to you for your significant suggestion for the development of standard of the students and as well as the lecturers, teaching faculty. We thank you, sir. We would like to thank Justice Indira Banerjee, the Supreme Court Judge for her inaugural address. See, first of all, I would like to thank Honorable Madam for having uttered a very sweet information that all Tamilians are well educated and we understand good English. So for these compliments she offered to Tamilians, we would like to thank Honorable Madam, and also we like to thank Madam for having remembered our what is this momentum which has been given to her at the time of her elevation to Supreme Court. And the role of the importance of 42nd Amendment of Indian Constitution, which paved various important role in the Constitution of Constitution importance. So we thank Honorable Madam Justice Indira Banerjee for her innovative and important, significant informations in her address. And also, I thank Justice Gopal Sriram for her address, Law and Justice in Malaysian Malaysian perspective. See, he compared Indian Constitution with that of Malaysian Constitution. The Constitution is Indian Constitution is sovereign, and the Parliament where Malaysia is Malaysian Constitution is sovereign, whereas India Parliament is supreme. So he has dealt speculations of various powers of Constitution. So I thank Justice Gopal Sriram for his elaborate comparison of various constitutions of in the world. I thank Justice Dr. Justice Vimala, who have been always with us for all our conference. In such a way, she has participated in this conference also and gave very powerful presentation in criminal administration and police administration. He mentioned a number of reforms to be made in the police administration. He also mentioned, though he pointed out some shortcomings in the police administration, she would never fail to point out the incident of a dedicated policeman who had to perform the last rites of her mother, but refused to accept the leave sanctioned to him. It was very touching. I thank Dr. Justice Vimala Madam for her very powerful presentation. Then I thank Justice Karunagaran from Seychelles on the topic for the presentation on the topic of administration of justice in judges' perspective. It was very interesting, and see, he said judicial delay. The quote we have to remember is the quote he uttered. The judicial delay is the enemy to justice. So how to avoid the judicial delay? How to avoid the clear the cases? How to avoid the delay of the cases? He has come out with various suggestions. For that, we are very thankful to you, sir, for your informative paper on administration of justice in judges' perspective. Then Thiru A. Shankaran அவர்கள் சட்ட ஆட்சி மொழி ஆணையத்தினுடைய உறுப்பினர், மிக ஆங்கிலத்திலும் அருந்தமிழிலும் அழகாக உரையாற்றக்கூடிய ஆற்றலுடைய அவர் இன்றைக்கு ஆட்சி மொழி ஆணையத்தின் பணிகளையும் தமிழ்நாடு ஆட்சி மொழி சட்டம் நடைமுறைக்கு வந்திருந்தாலும் கூட அந்த சட்டத்தில் தமிழ்நாட்டு சார்நிலை நீதிமன்றங்களிலும் உயர் நீதிமன்றத்திலும் தமிழ் ஆட்சி மொழியாக வருவதற்கு அரசு எடுத்த அத்தனை நடவடிக்கைகளை குறித்தும் பேசினார். ஆட்சி மொழி ஆணையத்தின் பயன்களை சொன்னார். இன்றைக்கும் சார்நிலை நீதிமன்றங்களில் இருக்கிற நடுவர்கள் தமிழில்தான் தீர்ப்பு எழுத வேண்டும் என்ற இருந்த அந்த முறையை இன்றைக்கு எதிர்த்து வாதிட்டு உச்ச நீதிமன்றத்தில் நிலுவையில் இருக்கிற அந்த வழக்கு குறித்தும் அவர் விரிவாக சொன்னார். இது குறித்து தமிழகத்திலே இருக்கிற வழக்கறிஞர்கள், சட்ட ஆர்வலர்கள், சட்ட நூலை எழுதுகிறவர்கள் எல்லோரும் இதற்கான தங்களுடைய ஒத்துழைப்பையும் உணர்வையும் வழங்க வேண்டும். அப்பொழுதுதான் தமிழ்நாட்டு சார்நிலை நீதிமன்றங்களிலே தமிழ் ஆட்சி மொழியாக வரும். தமிழ்நாட்டு உயர் நீதிமன்றத்திலும் தமிழும் ஆங்கிலத்தோடு சேர்ந்து ஒரு வழக்காடு மொழியாக வருவதற்கான அத்தனை நடவடிக்கைகளையும் மேற்கொள்வதற்கு பொதுமக்களுடைய உணர்வும் உற்சாகமும் தேவை என்பதை அவர் உரையிலிருந்து வெளிப்படுத்தினார். அவருக்கும் நம்முடைய இந்த மாநாட்டின் சார்பாக நம்முடைய நன்றியை தெரிவித்துக் கொள்கிறோம். அடுத்தபடியாக சீனியர் அட்வொகேட் ஆர் விடுதலை, he spoke on the federalism and concurrently. He boldly came out a decision, that suggestion that whether we have concurrent list or not, whether we should have concurrent list or not, either unionist, state list or list. So this suggestion, what I feel, this suggestion will help to find out solution for a number of problems, number of burning problems. For his suggestion, it's a bold suggestion. We are Vidalai, sir. Then Dr. M. Gandhi, Dean VAT Law School, an eminent law scholar, has presented his paper on international lawmaking. He listed a number of sources and their functions in the process of process in making international law. So also I thank Dr. M. Gandhi for his presentation. Finally, I thank Advocate V. Nalini for your request and a demand that பெண் நீதிபதிகளை அதிகமாக நியமிக்க வேண்டும். வழக்கறிஞர்கள் எண்ணிக்கையிலேயே ஆணுக்கு சற்று ஏறக்குறைய பெண்களும் வந்துவிட்ட நாளிலும் கூட நீதிமன்றங்களிலே பெண்கள் வழக்கறிஞராக இருக்கிற பெண் வழக்கறிஞர்களிருந்து நீதிபதிகளை நியமிக்க வேண்டும் என்ற அவருடைய கோரிக்கை சொன்னார்கள். அப்பொழுது எனக்கு பாரதியுடைய பாடல் நினைவுக்கு வந்தது. பட்டங்கள் ஆள்வதும் சட்டங்கள் செய்வதும் பாரினிலே பெண்கள் நடத்து வந்தோம், எட்டும் அறிவினில் ஆணுக்கும் கீழ்பெண் இளைப்பிள்ளை காணென்று தும்மியடி என்று சொன்னார். பட்டங்கள் ஆள்வதும் சட்டங்கள் செய்வதும் பாரில் நடக்க வேண்டும் என்ற பாரதியின் வாக்கை நினைவூட்டிய வழக்கறிஞர் நளினி அவர்களுடைய விண்ணப்பமும் கோரிக்கையும் நிறைவேறும். உரிய அமைப்புகளும் அதிகாரிகளும் அதற்கான ஆவணம் செய்வார்கள் என்பதை இந்த மாநாட்டின் மூலமாக நாம் தெரிவித்துக் கொள்கிறோம். ஏறக்குறைய 3 மணி நேரத்திற்கு மேலாக இந்த மாநாட்டில் எங்களோடு இணைந்து சட்டம் அன்று நீதி என்கிற இந்த தலைப்பிலான இந்த கருத்தரங்கில் கலந்து கொண்ட அத்துணை பேருக்கும் இணையத்தின் வழியாக கலந்து கொண்டு இந்த கருத்துக்களை எல்லாம் செவிமடுத்த அத்தனை பேருக்கும் நாங்கள் நன்றியை தெரிவித்துக் கொள்கிறோம். இவற்றை எல்லாம் இந்த கருத்தரை அமர்த்துவதற்கும் இரவு பகலாக நம்முடைய கடமையாற்றிய எங்களுடைய சட்டக்கதிர் ஆசிரியர் டாக்டர் V.R. சம்பத் அவர்களுடைய உழைப்பையும் உற்சாகத்தையும் ஊக்கத்தையும் அனைவரும் அறிவோம். எனவே தமிழுக்காக பாடுபடுகிற தமிழுக்காக பாடுபடுகிற நீதிமன்றங்களிலே தமிழ் ஆட்சி மொழியாக வர வேண்டும் என்பதற்காக பாடுகிற உலக நாடுகளிலே சட்டமும் நீதியும் நீதி தவறா நெறிமுறையும் நின்று விளங்க வேண்டும் என்கிற ஆர்வமுடைய அனைவரும் சார்பாகவும் நம்முடைய சட்டக்கதிர் ஆசிரியர் அவர்களுக்கு நாம் நன்றியை தெரிவித்துக் கொள்கிறோம். இந்த நல்ல வாய்ப்பை வழங்கிய சட்டக்கதிர் ஆசிரியர் டாக்டர் V.R. சம்பத் அவர்களுக்கும் என்னுடைய நன்றியை தெரிவித்து அனைவருக்கும் நன்றியை தெரிவித்து விடைபெறுகிறேன். நன்றி, வணக்கம்.
Thank you. You given a wonderful speech. Welcome, vote of thanks. நாளைக்கு இந்த நிகழ்ச்சி ரொம்ப சிறப்பாக நடைபெற்றது. நாளை காலையில் 10:30 மணிக்கு ஒரு ஸ்பெஷல் அகாடமிக் செஷன் இருக்கிறது. அதுல ஜஸ்டிஸ் அமர்வாணன், மிஸ்டர் சரவணன், மிஸ்டர் முத்துகிருஷ்ணன், டாக்டர் விஜயலட்சுமி, டாக்டர் சந்திரிகா சுப்ரமணியம் from Australia, Rajalakshmi Logamurthy, Miss Tulasi, Shireen from Delhi, Afi Devadas from Delhi, Surya, Ayor Purushothaman, Ayor topics of the lot of interesting topic. 10:30, the same ID code, same password you can use. The evening 5:30, the concluding session. Supreme Court retired Judge Mr. Gopal Gowda is coming, and also the Law Secretary Mr. Narayana Raju, the sitting member of Parliament and Senior Advocate Wilson, Dr. Tyagarajan Senior Advocate, Srikanth Raja from London, Raghunath Reddy, Professor from Bharat University, Prem Rajakumari. Then apart from that, the VAT Chancellor G. Viswanathan. Then the whole function presided over by the Honorable Justice P. Kalayarasan, Chairman of the Tamil Nadu Official Language Commission. So I am requesting you and all to participate tomorrow 10:30 session and the evening 5:30 session. All very interesting topic. Please participate and enjoy more knowledge on justice. Also, I want to show the law book, monthly law journal for your, because of the no advertisement, nothing, only 80 pages, English judgment. circulating all over Tamil Nadu. Anyone if they want, they can send an email to subscribe or to get a complimentary copy, whatever you want. We are ready to send it to you. Thank you, one and all. Thank you for your patience to be our 20 minutes for this whole inaugural session conference. வணக்கம், வணக்கம், வணக்கம். நன்றி.